Good, yes, thank you. Good afternoon. Welcome to the House Judiciary Committee. Today is February 17th, and our first bill will be House Bill 885 with Delegate Congolo. And with her will be Deborah Bocata.
Okay. Yes.
Well, Delegate, whenever you're ready.
All right. Good afternoon, Chair and members of the committee. For the record, I'm Delegate Latoya Congolo, and I'm here today to present House Bill 885, the Women's Freedom from Coercion Act. This legislation is a common sense necessity. It prohibits any person from knowingly and willfully causing another to ingest an abortion-inducing drug through fraud, coercion, force, or threat of force. While Maryland is a leader in protecting reproductive justice, our current laws contain a dangerous justice gap that leaves women uniquely vulnerable to abuse. Currently, if someone has slipped an abortion-inducing drug to a pregnant person through deceit, such as hiding it in food or a drink, or in some cases lying about what the medication is, the offender often faces only misdemeanor charges with minimal jail time. This is a profound insult to a victim's bodily autonomy and the gravity of their loss. House Bill 885 closes this gap by establishing that causing the non-consensual ingestion of these drugs is a felony punishable by up to 10 years in prison. I want to address the concerns raised by those who fear this bill is redundant or targets medical providers. I've done my research and I can tell you it does not. The scope of House Bill 885 is strictly limited to the criminal acts of third parties who act without consent. It does not prohibit the manufacturing, legal sale, or professional administration of abortion and medication, nor does it create new liabilities for pharmaceutical providers acting within the law. Maryland prides itself on reproductive freedom. That freedom must include the choice to carry a pregnancy to term without fear of chemical coercion. By passing House Bill 885, we make Maryland the foremost protector of women's health and ensure that the right to choose belongs solely to the individual protected by the full gravity of our laws. So I urge a favorable report on House Bill 885. Thank you.
My name is Deborah Mercado. Good afternoon, Madam Chair and delegates. You have my submitted written testimony. As a retired registered nurse, I am strongly in favor of House Bill 885. I am also a former volunteer of over 8 years at a pregnancy resource center. At the center, I heard lots of stories of coercion from the women. There were threats of violence and actual physical violence as well as abandonment. The message was get an abortion or get out. There's a new threat to pregnant women. It is very easy for persons with ill intentions to obtain abortion pills and use them against unsuspecting pregnant women. There is no in-person exam by a physician required. The pills can be prescribed via telehealth, and any number of people who don't want the pregnancy to continue could get the drugs. When given correctly, abortion drugs are given in doses. Even when taken as directed and willingly, the woman is at risk for serious injury such as hemorrhage, sepsis, infertility, and death. The abuser does not care about the correct way to give the pills or the risk. The abuser is likely to crush the pills and put them in her food and drink all in one big dose. Giving them all in one big dose increases the likelihood of serious injury. The woman could not only lose the baby she currently carries, but also the ability to have any future children. This type of assault takes plenty of preparations. It is premeditated. The abuser is attacking the woman's body for the specific purpose of ending a pregnancy she wants to continue. The Reproductive Freedom Amendment was added to the Maryland Constitution to guarantee a woman's right to make choices about her pregnancy. Violating a right delineated in the Maryland Constitution merits special recognition. This intimate attack on women needs to have a unique designation in the criminal code and an appropriate penalty to provide justice for the violation of her rights and her body. Women deserve a path to justice. Please protect a woman's bodily integrity and her right in the Maryland Constitution to continue her pregnancy. I strongly recommend a favorable report for House Bill 885. Thank you.
Thank you. Members, do we have any questions? Seeing none, that ends the House, the hearing for House Bill 885. Next, we're going to just change the order just slightly, and we're going to hear Delegate Ampry with House Bill 687. Can you give me 1 second, Delegate Ampry?
That's fine, that's fine. I had to put a little Mardi Gras flavor. The purple was as close as I could get. I'll have to get a green suit for next year.
Okay, Delegate Ampry, we have, is this Phil Woloski?
Yep.
Yes.
Hi there, how are you?
There should be someone online.
Yep, and we have folks online, but I just want to make sure I get everybody who is here. So just Mr. Woloski. So you all can begin whenever you're ready. Thank you.
Thank you. First, I want to say it's a pleasure to be before you, and congratulations again, Madam Chair. It's my first time before your committee as in your new chairmanship role, so I want to say congratulations to you. For the record, Delegate Marlon Ampry here in support of House Bill 687, Criminal Procedure Evidence Protecting Artists' Creative Expression. I like to believe that the third time's a charm, but that didn't work out for me. So this is our fourth time hearing this bill. So I like to say this is the fourth quarter, all right? So this is an opportunity for us to get it right in the fourth quarter and bring this bill into a victory. So House Bill 687 establishes clear guidelines for when artistic expression can be admitted in court, ensuring that creative works are not misinterpreted as fact or weaponized against artists. This bill protects free expression while maintaining fairness in the legal process, reinforcing that Maryland values both justice and creativity. And I want to be clear, House Bill 687 does not ban the use of lyrics or creative expression in court. You can still use it in court when it is applicable. All it does is it requires a court to apply certain clear evidentiary standards before admitting such evidence. Under the bill, artistic expression may only be admitted if a court finds the artist intended the expression to be taken literally rather than as fictional, figurative, or symbolic speech. The expression directly refers to the specific facts of the alleged offense, and the expression is relevant to a disputed issue of fact in the case rather than offered solely to suggest character or publicity. This approach strengthens the integrity of the judicial process while preserving both public safety and constitutional protections. Now, some may ask, why do we need this bill? Well, clearly, as you can see across this country, as you all have heard over the years, the horrible examples of when people have misused creative expression in court. We've had a person come and testify amongst this committee, Mac Phillips, who described where he spent over 18 years in prison because a prosecutor took some language from some of his songs, meshed them together to show that he may have done a crime, when come to find out someone else had already admitted to the crime, right? So the goal of this legislation is not to say you can't use this information. It just shows that you have to pass a certain threshold and test to make sure it's not used incorrectly. And on top of that, we don't know how often this is actually happening. We know about the court cases that get to the court, so we don't know about all the plea deals that are happening, where young people are being told, "We're going to play this song in the courtroom. Go ahead and take this plea deal, so you don't have to hear this song in the courtroom, because I know they're gonna definitely lock you up if they hear this song." Our goal is to make sure that that's not happening to our young people. So, House Bill 687 does not prevent prosecutors from introducing relevant evidence in serious cases, including domestic violence, child abuse, trafficking. The bill does not apply to factual admissions, victim-specific statements, or writing that directly describes criminal conduct. You may have heard you will see from opposition that they believe that this bill will make it harder for them to introduce certain types of evidence. That's not what we're doing. We're just making sure that bad evidence is not introduced to the court and that we're not wasting taxpayers' time and money. Maryland has long been a place where creativity thrives. You must ensure that artists, especially those in historically marginalized communities, can create without fear, and their words will not be misused against them in the courtroom. House Bill 687 protects free expression and upholds fairness in criminal proceedings. And I'll lastly just say, today we signed a bill in regards to what's happening with ICE. We know that a lot of these situations are happening across our nation. And I know we don't have to wait for a major issue to happen in Maryland. We get in front of things like we did today. So I'm hoping that we can pass this bill and get in front of this issue and make sure it doesn't become a pervasive problem here in Maryland. With that said, I ask for a favorable report on House Bill 687, and I'll hand it over to my panel.
Thank you. My name is Phil Woloski. I am the executive director of an organization called Free Our Art. It's a coalition organization of a variety of arts groups, including the Recording Academy, the Recording Industry Association of America, PEN America, SAG-AFTRA, and a whole lot of others in an alphabet soup of various arts organizations. You're familiar with this bill, right? It's year 4, as Delegate Ampry said, and we're proud to have 10 members of this committee as sponsors. And I'd note that broad sponsorship, I think, tells a story about doing this bill the right way. This bill has bipartisan support. both on this committee and off of this committee in the House of Delegates, as well as in the Senate. We have Ranking Member Chris West of the Judiciary Proceedings as a sponsor, as well as Johnny Motz on the Republican side, and then Nick Charles and Senator Charles Sidnor as sponsors. Every part of Maryland is represented on sponsorship of this bill. Not a lot of bills have the support of both unmistakably liberal and conservative organizations. And we are very grateful this year to have the courageous support of State's Attorney Ivan Bates, who has recognized and candidly would be in some ways limiting his own ability to kind of use lyrics as they're used today, or creative expression is today, in an unlimited fashion. We have also integrated feedback from this committee in years past, including the definition of creative expression and limitations on juvenile use at the request of former Chairman Luke Clippinger. And I know that there has been some fear-mongering about, oh my goodness, all these terrible things are going to happen if this bill passes. The reality is that California passed a bill 3 years ago. We actually built this model legislation because we thought the California bill was so, let's say, California, that it would pass nowhere else. That state has not fallen into chaos and disrepair and lawlessness. So when people talk about the idea of genuine bipartisanship, very often there's eye rolling. This bill proves that it can be done, especially when we focus on core American values like the First Amendment. Thank you so much for your time.
Thank you. Members, do we have any questions for this panel? I'm going to go ahead and call up our online panel, Favorable. Lucius Outlaw. Okay, Mike Squirrel. And Latasha Nance. Okay, we'll start with who's in the room. Hi, Mr. Outlaw. We are ready for your testimony. You'll have 2 minutes, and whenever you're ready to begin.
Thank you. If you can give me a thumbs up to see if you can hear me.
I can hear you. I'm just telling my interns to turn up the volume, but you're fine, Mr. Outlaw.
Well, thank you. Good morning, distinguished delegates. My name is Lucius Outlaw III, and I'm a professor at Howard University School of Law, where I teach criminal law courses. Today, I speak on behalf of myself as a criminal law educator, criminal defense attorney, former public defender, and a lifetime fan of hip hop. Please note that I speak for myself and not as an official representative of Howard Law School. Today, I speak in support of the PACE Act. I'm using my time to address 2 common objections to the proposed law. 1, the law is not needed due to existing case law precedents. And 2, the law would deprive prosecutors of valuable evidence to prosecute dangerous and harmful criminals. The first objection, that is, the PACE Act is not needed due to existing law precedents, is just simply not true. There are good precedents where Maryland courts have barred prosecutors from using defendants' rap lyrics as evidence. However, these precedents are not sufficient substitutes for 3 reasons. 1, case law precedents do not establish clear lines in the same way as court rules established by statute. 2, case law precedents are consistently exposed to being overturned or diminished by subsequent trial and appellate judges. And 3, prosecutors and courts rarely distinguish the present case from a precedent to avoid applying the precedent's holding and rule. The second objection, the law will deprive prosecutors of valuable evidence. This is also not true. The PACE Act is not a complete bar to prosecutors using rap lyrics or other artistic expression as evidence. Instead, the PACE Act imposes a test for prosecutors to satisfy if they want to use a defendant's rap lyrics or artistic expression as evidence. It is a test that is consistent with Maryland case law, and it embodies the thrust of the precedents, that to be relevant and admissible, a defendant's artistic expression must have a direct nexus to the facts of the charged case. Rap and hip hop has evolved from being an underground music genre dismissed as a fad to a cultural phenomenon of great influence. Yet despite this influence, the only place that hip hop has still not achieved the respect on par with other art forms is in our criminal courts. It's time to change that, and the PACE Act is an important and needed step in the right direction. Thank you.
Thank you. Mr. Mike Squirrel?
Yes, hello.
Hello, Mr. Squirrel. Do you have a visual? Do you have a camera? Or
Yep, there we go.
there you are.
All
Okay,
right.
great. Whenever you're ready, you'll have 2 minutes for your testimony. Thank you.
All right, I'm ready. Good afternoon, and thank you for the opportunity to speak today. My name is Michael Squirrel, also known as Squirrel Wide. You know, I've been a radio personality for over 25 years, and during the time, I worked closely with artists, creators, and young people who use music as a form of expression. So I'm here today to support the House Bill 687, the PACE Act, because I've seen firsthand how music is created and what it represents. Music is storytelling. It reflects imagination, emotion, creativity, and perspective. Many times artists are speaking symbolically and creatively. It's not meant to be taken literally. Art is not confession, it is expression. Creative expressions can reflect feelings like ideas or storytelling. Without proper context, it can easily be misunderstood. All right, so this issue has been especially visible in hip hop, but it doesn't just apply to hip hop. It's in country music, it's in rock, it's in film, it's in poetry, literature. I mean, it's telling stories. So it should be applied to all creative expressions equally. And I also think that this bill provides reasonable safeguards, and it does not prevent injustice. It does not prevent justice. It simply assures your creative expression is not unfairly used or taken out of context. I also feel that art should be recognized for what it is: creativity, storytelling, and expression, and not automatic evidence of wrongdoing. So I respectfully urge people to support House Bill 687, and thank you for your time and consideration.
Thank you. Appreciate your testimony. Members, do we have any questions? And Mr. Squirrel, I just want to tell you, it sounds like you have some fans here today. Delegate Carden.
Chair, thank you very much for all your compelling testimony. This is really for the law professor to ask the question. So you would, in your second point that you made about that there's a test that's required to be taken for the prosecutors to be able to use the evidence, that they have to find a nexus. Isn't that already the case with in the rules of evidence, that you have to find, for it to be considered relevant, there has to be some sort of nexus? And can a judge just make that determination right then and there?
That is a rule, but like all rules, excuse me, of law, there's exceptions and other ways to get around, namely Rule 404, bad acts evidence is one example, whereas it may not be tied to the facts, but it can be used to show that somebody had the intent or had the knowledge needed to perform the crime. And that's how prosecutors a lot of times will get around such relevancy rules to say, well, it doesn't reflect the facts of the case, but these rap lyrics show that someone has drug knowledge, and that's why the evidence can come in. And the PACE Act will say, no, you can't do that end run around these rules to show propensity type evidence or character like evidence.
Okay, thank you. Thank you. I guess it would. Okay, thank you.
Thank you.
I'm sorry, can I add just one thing?
Sure.
Delegate, that language, the nexus language, actually comes directly from the language in Montague versus Maryland, a case in which the court did not allow evidence in, it did allow evidence in, forgive me. So basically the Supreme Court of Maryland decided that evidence was properly admitted. We based this bill off of that court decision by the Maryland Supreme Court that basically allowed evidence in. So in other words, very much intended to create a pathway for prosecutors to be able to bring things in.
Thank you. And Delegate Taylor?
Thank you, Madam Chair. I guess my question is also for Professor Outlaw. I mean, Delegate Carden kind of touched on it, and you did answer some of this, but it's concerning that the state's attorneys, several of them, and the State's Attorneys Association has, all kinds of issues with this bill. And it almost seems like if we pass this bill, that they feel like they can't have additional evidence given in the case. Does that make sense? I mean, I'm feeling the spirit of, if we pass this bill and that's it, there's no more evidence that they can use against a particular offendant.
Thank you for that question. And I will say I understand their position, them being prosecutor, but to me, it's kind of interesting that they're objecting to a test that says, if you want to use evidence, just show that there's a factual and temporal nexus to the charged offense. That's what the test is. All you have to say is, these lyrics have a close nexus to the actual facts that we are alleging. And it's very bewildering that prosecutors would object to that sort of test, that is some type of crazy burden to put on them, that if they want to use artistic expression, they have to show that their artistic expression actually reflects the facts of the case. And to me, in opposing that, shows that they understand that they want to use that evidence, have access to that evidence for other reasons. And there's been study after study and after study that shows that people on average have a more negative reaction to rap lyrics than artistic expression in other musical genres. That people associate rap lyrics with violence, and people who do and perform and write lyrics are more associated with crime and violence. And that's what just allowing this artistic expression to be used without limitation or guardrail. That is what this evidence taps into. It taps into biases and prejudices against rap music and people who perform and compose rap music. And just to go back to the prior question about whether or not we need this because there's already a relevance and we already have precedents, there's a case from 2025, and it's Frazier versus State, 2025 Westlaw 1732965, that was decided by the Maryland Court of Appeals on June 23rd, 2025, which it involved someone who was involved with a shooting. He claimed self-defense. The government said it wasn't self-defense, and they wanted to used two of the defendant's rap songs at trial. And when it went up to the appellate court about the proper use, whether or not those rap lyrics were properly introduced, the court actually looked at the Montague case that set the factual nexus standard. And this is what they said. Quote, in Montague, the court's task was to determine whether the events described in Montague's rap lyrics bore a, quote, close factual and temporal nexus between the rap lyrics and the details of the alleged crime, end quote. This court's task is related but somewhat different. Rather than looking for a close nexus between the lyrics and the details of the crime itself, we must examine Frazier's rap lyrics and determine if they include any statement bearing on why Frazier shot the victim. And so again, this is why a statute that imposes an actual rule is needed, because courts can easily distinguish the cases that set that factual nexus and do an in-round and say, well, we're not using it, we're not going to find the actual facts nexus, but we're going to say because he wrote violent lyrics, that somehow shows his intent to kill the victim. And that is the problem that the PACE Act solves, that it doesn't allow this very attenuated connection when there's no factual or temporal nexus between the artistic expression and the facts of the case.
And I just want to add one more thing, just in regards, if it's okay, Madam Chair.
Well, it's okay, but quite frankly, your panel kind of closed when I asked the members if they had any questions. However, I did allow Mr. Wolotsky, so I will allow you, Delegate, to go ahead and add whatever you wanted to add.
Yeah, I just want to add, as a legislator, I think it's important that, the Montague case has been the standard, but I think it's important that when we have a good standard, you codify it. I think that we in this country can already feel the effects of our failure to codify Supreme Court decisions. We're now living through a world where we decided we could rely on court decisions. If we have a good law that we think works, that is fair, we should always try to codify it to make sure that it can be preserved. So I just want to add that, because we're looking at the Montague case as the standard. I think this bill literally just codifies the Montague standard. So I just want to add that.
Thank you. Delegate Conaway, do you still have a question? No?
Thank you, Delegate and witnesses, for coming in. So can you explain again, how does what's Montague case, how does this codify that?
So the standard that we've laid out in this, like the test that we had, the three-prong test, was the test that was put forth in the Montague case in order to determine whether or not lyrics could be used in that trial, which they determined that they could be used. But that's the standard that courts often go back to. So if you look here, this most recent case, they went all the way to the appellate court. that they had to figure out and look at the standard. Well, if we have this clear test that can be used at lower courts, we're going to save prosecutors time and money. We're going to save taxpayers time and money because we have a clear test and standard that can be applied at the very onset of the case instead of us having to wait to go to the appellate court and then determine from all the cases which one should be used as the standard. So I think by codifying it, we make it simple and easy for people to be able to follow a clear guidelines, clear laws, so it's fair and equitable for those who are trying to use the evidence.
Thank you, Delegate.
The Vice Chair?
Oh, I'm sorry. I was doing it for you, Valentine. I've got a question. I understand that State's Attorney Bates is in support with an amendment. Can you elaborate a little bit on the amendment?
I believe, what's the amendment? The amendment is to.
I didn't see it.
It's around probative versus prejudicial standard. Versus
Yeah, I think it's he wants to go back to probative, and I think we're open to the conversation. I don't want to commit to anything. I want to analyze in more detail of like what that actually would mean. But I'm open to the conversation. I think we're at a point now where this bill can get across the finish line, and if that's going to be the hurdle, then I think we figure out meeting of the minds, figure it out. We know that bill hearings aren't the deciding point, right? We're going to have more conversations about this. I look forward to working with his office, and he's been very helpful in us walking through this and understanding it. And I really appreciate his taking a stand on this.
Thank you.
Yeah.
Thank you. And I understand that Latasha Nance has joined us. Ms. Nance? Hi. You all have 2 minutes for your testimony, please.
Hi, good afternoon. My name is Latasha Nance, but I go by Siv Jones, and I want to say thank you to the chair and the committee members for this opportunity. I am an author of a hip-hop book called 7 Lessons That Hip-Hop Taught Me That School Didn't, where I touch bases on all of the positive things that hip-hop culture has taught the listeners and fans. I'm also a former personality for Baltimore's Radio 1 station, where I held the position working in several different aspects of the radio station, being an on-air personality, a producer, etc. I'm here today to support House Bill 687, the Protecting Artists' Creative Expression Act. Through my work as an author and a mentor for young children, working with Keys Development, where we taught used hip hop culture to help students with their depression and just using hip hop culture as a positive expression. I have spent several years working with inner city youth and emerging artists. I watch young people use music, especially hip hop, as a powerful storytelling tool. Their lyrics are influenced by urban life, social pressure, and community challenges that shape many of our neighborhoods. What's important to understand is that much of this storytelling is autobiography. It is a narrative. It draws connections between audience who share similar backgrounds and struggle. It speaks to environments shaped by economic hardship, systematic inequalities, violence, resilience, and sometimes the allure of fast and glamorous lifestyle. These themes are a part of the culture conversation and not a confession. Hip hop has always used metaphor, symbolisms, creative perspectives to reflect on lives' experience, social commentary. It's always been used as a tool to talk about some of the things that have gone on in the communities when it has to do with Black cultures. When we make the
So, Ms. Nance, that was your indicator that your time is up. Did you want to finish your sentence or finish your thought?
Yeah, I just wanted to say that this is just about fairness. It's about understanding art as an art and not as a confession, so that these lyrics should not be used in that aspect.
Thank you. Members, do we have any questions? Delegate Moreno?
Thank you, Madam Chair. So I'm not a rapper, but I've listened to a lot of rap songs. And so when I look at this legislation, and I am sponsoring it, I have a couple questions, or I have one question. Does this bill create complications for solicitation or incitement cases? So, for example, if a rapper releases a song doxing a specific person, and then an unrelated listener commits a crime against that person and says, I did it because the rapper told me to do it, would that statute make it harder to use as the song as evidence and as the rapper's potential criminal responsibility in that type of case?
Yes, yes, it will make it hard to use.
Oh, no,
the-
no,
Sorry, I think.
Oh, so it was for any panelist, to be honest. But yeah, if anybody wants to take it.
I could attempt to answer it, but I'm gonna go with the professor because he's a professor.
Yeah, Professor Outlaw.
I would say no, because I guess in that situation, one, the government would have had a witness that would say, this person was communicating to me with this song, and I understood it to be a solicitation. So then the government could say, well, there's a factual nexus to the case. So I don't see it that way. And also in other, there are laws that criminalize making threats against another person. And in fact, there's been a number of cases where rap lyrics have been not only the evidence, but the actual crime, where somebody threatens someone in a rap song and the court and juries find, no, that was like a real threat that doesn't have First Amendment protections. So the PACE Act would not create a barrier to that, because if somebody is saying, just puts to beats and music saying, hey, if you go kill this person, I'll pay you $10,000, and somebody says, I took that and I went and tried to do it, and that person's cooperating with the government can establish a factual nexus between the song and the alleged conduct. So no, it would not be a barrier.
All right, thank you. And it sounds like you created a contracts exam fact pattern there too. Thank you.
Thank you. Members, do we have any other questions? Do we have State's Attorney Ivan Bates on in the Zoom room? Okay, he is signed. I'm sorry? No? Okay, he is signed up as favorable with amendment. So seeing no further witnesses and no further questions, that concludes our testimony for House Bill 687. Thank you very much.
Thank you so much, Madam Chair.
Next, we're going to call up Delegate Conaway. Are you ready? Okay. So we're going to call up Delegate Conaway, and he should make himself comfortable because he's going to be there a while. House Bill 749 is our first bill that we're going to call up.
Thank you. No, Chair. Generally me. I'm back again to see the committee. Happy to see you all, the committee and chairperson. And Delegate Conaway here to pick back up from where we left off last year. So House Bill 749 is a criminal procedure bill, and what it basically does is says that the victims and their representatives have to be notified by the state's attorney when there's some action involving their cases. The bill requires the prosecuting attorney to notify the victim or the victim's representative in specific misdemeanor theft cases, each court proceeding related to the case, and the right of the victim to submit a victim impact statement. And basically that's what the bill does. It gives some more rights to the victim to be notified and for them to give input. And I'll be glad to answer any questions that I can.
All right. Any questions?
Thank you so very much, and I would request a favorable for that.
We're going to call HB 757. Delegate Conway, you may proceed.
Okay, thank you, Chair and members of the Judiciary Committee. Delegate Conaway here to introduce continuation of theft of mail and packages and victim notification bill. And this is House Bill 757. Basically, what this does is it changes this to a felony, which is subject to an imprisonment of up to 5 years. The fiscal note has several different violations and guilty dispositions, from stolen items, from theft less than 100 all the way up to theft more than 1,000, and you can look over it, but less than 100, it's 875 people or cases for 2025. From 100, but less than 1,500 is 1,796 cases. So what we're trying to do is get people to stop stealing your packages. And with that, I'll be glad to answer any questions if I can.
Delegate Conway, I understand you made a deal with the chair that you could proceed with all of yours at one time without interruption, so go.
I don't know about that, Judge, about deals with the chair and all of it. I know where I'm at, so I don't know that I said that, okay? All right.
Well, you may proceed, sir.
Thank you very much, Chair, members of the Judiciary Committee, Delegate Conaway. I'm here to introduce House Bill 760, Criminal Law, Misdemeanor Theft, and Statute of Limitations. The current statute of limitations for theft greater than 100 but less than $1,500 is currently 2 years. Now we know that there might need to be a little bit more time to investigate what was stolen, who stole it, get your pictures together, maybe from your porch piracy camera. And what this does is suggest that the time limit increase from 2 years to 3 years. And with that, I'll be glad to answer any questions if I can.
Seeing no questions, you may proceed.
Thank you so very much, Chair, and thank you, committee, and I would ask for a favorable. Okay, House Bill 767, I'm Delegate Conaway here introducing criminal law theft and opening packages, House Bill 767. What this bill does is makes the theft of opening and stealing your packages a felony instead of a, instead of a misdemeanor. And what happens is, because it's going to be a felony, it's not subject to imprisonment exceeding 5 years, and the person who was convicted shall pay any administrative costs relating to this, the theft and the procedures. And I'll be glad to answer any questions about that if I can. Excuse me.
No, seeing no questions, you may proceed with the next bill.
All right. And I should say that Delegate Tolles was very helpful with me. We worked on these bills together last year, and unfortunately she's not on committee, but I think we'll see her again. And so some of the bills came in as a duplicate. The Delegate Conaway here to introduce House Bill 782. So what I had to do was because it was a very large bill and had several different moving parts, I had to break down each part of the bill and deal with it in subsections. House Bill 782 changes the fine from $15 for the misdemeanor conviction up to $500, and it leaves the current imprisonment maximum fine is the 6 days. So what it's going to do is say that the fine is up to $500 and up to 6 days imprisonment for taking and breaking open letters and packages that's received through the mail. And I'd be glad to answer any questions in reference to that.
Seeing no questions, sir, you may proceed.
Thank you very much, Chair, and thank you, committee, and I would ask for a favorable. Good afternoon again. This is Delegate Conaway introducing House Bill 786. This is a criminal law theft mail package. This is a carryover of the Porch Piracy Act, which I spoke about in reference to Delegate Tolles and I. We worked on several of these packages together, several issues in reference to this together. And under this bill, the person who violates this is guilty of a felony and conviction subject to imprisonment not exceeding the 5 years. As a condition of sentencing, the court shall order the defendant to restore the mail or package taken to the person to whom the mail was addressed and pay restitution for the mail, for the value of the mail or the package. In other words, if somebody steals your package, you know who it is, they have to reimburse you for the package or give you your package back. And that's what this bill basically says. I'll be glad to answer any questions in reference to that.
Seeing no questions, sir, you may proceed.
Thank you so very much, Chair. Thank you, committee, for indulging me, and I would ask for a favorable. Okay. Good afternoon again. This is Delegate Conaway here to introduce House Bill 787, Criminal Law, Theft, Mail Packages, Porch Piracy Act of 2026. This is a part of the big bill that we took apart. And what this does is the bill prohibits the knowing or willful theft of a mail package, which is defined as an item delivered or left collected by the United States Postal Service or delivery service that delivers tangible personal property. Violators are guilty of a felony on conviction of first, second offense. The court must order a violator to restore the mail or the package to the addressee or pay restitution for the value of the mail or the package. A third or subsequent offense is punishable by imprisonment for not less than 6 months up to 3 years and or a $1,500 maximum fine. Additionally, as a condition of sentencing for the third or subsequent conviction, the court may order the violator to undergo evaluation and treatment for substance use or disorder. You have certain people, as we've heard in testimony in the past, that they like to frequent other people's porches and steal their packages. And they get caught once, twice, 3 times. But at the third time, they need to be evaluated. It might be something else going on. They might have, drug disorder or something like that. They just can't help but steal off your porch. So with that, I'll be glad to answer any questions if I can.
Colleagues, any questions? All right, seeing no questions, you can proceed, sir.
Thank you so very much, and I would ask for favorable disposition for that bill. Thank you very much for entertaining me today, Judiciary Committee and Chair. I'm Delegate Conaway here to introduce House Bill 788. Again, this is a part of the bill that we worked on so hard last year, the Criminal Law, Theft, Mail Packages, Porch Piracy Act. That was 2025. This is listed as 2026. And again, I expect that once I'm finished, I'll turn all of these documents over to the committee, and the committee will be able to put this back together in a beautiful way. So what this bill does is prohibit the theft of mail or packages delivered or left to be collected by the United States Postal Service or a delivery service company, authorizing the court to order a person convicted of a certain crime to stay away from certain locations, and providing that a person who violates the act is guilty of a felony and is subject to imprisonment up to 5 years. What this means is that if this person, your friendly neighbor, every time UPS pulls up or the Postal Service pulls up, they come to see what you have on your porch, and you have them on your porch several different times. Well, they can get a order to stay away, and they'll be subject to imprisonment up to 5 years, and it will be a felony. So with that, I'll be glad to answer any questions if you have them.
All right, colleagues, no questions? All right, you may proceed, sir.
Thank you so very much, and I would ask for a favorable in reference to that bill. Good afternoon, committee. Delegate Conaway here to introduce House Bill 0792. Okay, this 792, again, is a part of the Porch Piracy Act, but I think that this was actually came in as a duplicate of one of the previous bills, the bill you just heard, and I'll straighten this out. I have to ask that it be withdrawn due to the repetition of the bill drafting, okay? So with that, I'm going to ask that bill be withdrawn. Okay.
All right, you want to proceed with the next one?
Yes. Thank you so very much, Judiciary Committee and Chair. I'm Delegate Conaway in reference to House Bill 793. And it's a criminal procedure theft, notification of victims and victims' representatives. Okay, so in what this bill does is requires the prosecuting attorneys of thefts of properties or services of value less than the $1,500 to notify the victim or the victim's representatives about each court proceeding, the right of the victim to submit a victim impact statement and post-trial court proceedings, any appeal, and any sentence review related to the case. So you know the different cases have different values, and what we're trying to do is cover the most extreme values and coming on down to the least values. Because really, this stealing of packages and mail, it's a terrible nuisance, and it's getting kind of complicated. Now we're getting ready to go to our doorbell cameras and whether or not we can record inside or outside. So what we're trying to do is tell people to stop stealing packages off of your porch, because there's going to be some serious consequences. And with that, I'd be glad to answer any questions if I can.
All right, seeing no questions, you can proceed with the last bill.
Thank you, Chair, and I would ask for favorable on that bill. Again, Delegate Conaway here to introduce House Bill 847. 847, criminal law, fraud, possession of residential real property. This is what you really call squatters. So we had a lot of action last year in reference to squatting, and I learned a lot of information. I thought that if someone was in your home and you come home and you can prove that at your house, the squatter has to get out immediately. But I've come to find out that that's not really how things work, because we have some very elaborate fraudulent schemes going on here in the state of Maryland. So everybody's rights have to be considered, because some people are being duped into believing they're renting property when they really are not. It's not the property that they're renting. So what this bill does is prohibiting a person from possessing or claiming a right to possess residential real property the person does not lawfully possess or own with the intent to defraud another, authorizing the owner of certain residential real property to file a certain sworn affidavit, and requiring a law enforcement officer to remove a certain person from the residential real property under certain circumstances, and providing that the act does not prohibit the owner of the residential real property from filing a wrongful detainer. And with that, I'll be glad to answer any questions that you may have.
All right, any questions? Delegate Boucher.
Thank you, Chair. Thank you, Delegate. Have you been a victim of this? Do you bring this experience to the table?
No.
Okay. No, thank you. I thought maybe you had personal experience.
No, I have security.
All right. Thank you. Very much.
Thank you, Delegate Cardin.
Thank you, Madam Chair. Thank you very much for bringing these again.
Thank you, sir.
We appreciate it, and I know that you're maybe last year you put together like this into one omnibus bill, right?
Yes.
It just didn't make it over the finish line, right? We had one bill, I think it was Delegate Solomon's bill that made it over.
It didn't make it over the finish line. It's just too many moving parts.
Okay.
So therefore, that's why I tried to break down the different moving parts into subsections.
Okay, so just two quick questions. The first is, your House Bill 782 for increasing the fine from 15 to 500 for taking an opening. That's different. That would be a separate charge from a theft charge, because it's not actually I'm looking at the statute. It doesn't look like it's a theft charge. It's a separate charge.
It's taking an opening, right?
Even though that would, I guess by definition, be theft, you could charge them with both, couldn't you? Or you don't?
I don't know that.
Well, I'll talk to a prosecutor about that and see if they can. The other question was about 788, about the stay away orders, right?
Yes.
So would it maybe make sense to try and change that to expanding a peace order for giving a judge the ability to allow for a peace order for somebody who has been accused of stealing mail, even though it's not necessarily a physical altercation? It would maybe giving the judge the ability to do it so that you could have the stay away that way. Might that make sense?
That could make sense.
Okay, maybe we'll talk about that.
We'll talk about it. I appreciate all of your input this year and last year.
Colleagues, this concludes the favorable testimony on HB 847. There is an unfavorable. I'd like to call Matt Hill.
Thank you, Chair. Thank you, Committee.
You may proceed, sir.
Good afternoon, Madam Chair, members of the committee. My name is Matt Hill. I'm an attorney at the Public Justice Center. I appreciate your time today. I appreciate the sponsor of the bill. But I want to thank the committee for the work last year in addressing issues and concerns around squatting. There was a deliberative, thoughtful process by this committee. And at the end of that process, the committee recommended and was enacted to expedite the wrongful detainer process so that you, from the date of the complaint to the date of trial, is 10 business days. So it's one of the fastest court processes now in the state. And this committee thoroughly examined the issue. That bill only took effect on October 1st. And so there's not been really any time to evaluate that. And I've never seen any data or any evaluation from the proponents of some of the bills you're going to hear about with respect to squatting. And so I'd urge the committee to let that bill have time to work and to evaluate that impact. Secondly, squatting is already a crime. Trespass, burglary, fraudulent lease is already a crime in the state of Maryland. Further criminalizing that conduct is not really going to address some of the root cause of the problem. Some of that root cause we've seen, and I agree with Delegate Conway, is that some people are being drawn in by these Facebook marketplace scams. And that's become easier with the advent of these kinds of scams online. To address that root cause, we propose, and I think Delegate Embry may have a bill about this, to hold Facebook accountable, to have Facebook have to verify when whether someone's actually authorized to lease out a property when they post something. That would eliminate some of the problem that you're seeing. And third, Delegate Conway's bill unfortunately, it would bypass the court process and allow someone who claims to have the right to repossession completely skip the whole court process entirely and go straight to the sheriff. That violates my clients' constitutional rights as renters when they've been accused wrongfully, as many of our clients have, of being squatters. 2 of those renters are featured in my testimony. There was an article in the Baltimore Banner about them, Madison Plius and Felicia Lemon. I'd encourage you to read that if you're interested to understand how this works with real renting families who are wrongfully accused of being squatters. Thank you.
Thank you, sir. Any questions for this witness? Mr. Conway, Delegate Conway.
Thank you, Vice Chair. Thank you for coming in to testify. In reference to the 10 business days, I looked at the 10 business days, and as you know, I was one of the sponsors of the bill last year, and this wasn't what the judges came up with. So in reference to the 10 business days, what do you do in the case of 2 snow days and maybe a holiday? How does that throw off the business days? See, what I'm trying to get to is, if you know that you filed on a Monday, you know 2 Mondays after that, 2 weeks, you should be in court. You should be getting your property back, talking to someone. Now, if you have 2 snow days like we just had, that could throw you off. Instead of you being at 10 business days, which is what, 14 days, you could be at 16 days or 17 days out of your property.
Yes, Delegate, I know you have a bill to change 10 business days to 14 calendar days. We have no objections to that bill. We'll be on the same side.
Okay. Well, I just wanted to say that because you mentioned the 10, but thank you so very much.
Any further questions for this witness? Thank you, sir.
Thank you.
That concludes the testimony on HB 847. Thank you, Delegate Conway. All right, I'd like to call HB 765 with Delegate Griffith.
It's like I'm back on the committee this year. All right, to get started, Chair Bartley, Vice Chair Davis, members of the committee, for the record, my name is Delegate Mike Griffith. I'm requesting a favorable report on House Bill 765, criminal law, counterfeiting and possession of a counterfeit lease penalty. This bill would classify the fraudulent creation of counterfeit leases and rental agreements as a felony under Maryland Criminal Code. This bill is straightforward. It adds leases and rental agreements to 8-601 of the criminal law article, ensuring that individuals who create or use fraudulent leases can be prosecuted and penalized appropriately. Under current law, the possession of counterfeit leases is not treated as a felony, leaving law enforcement, prosecutors, and courts limited in their ability to impose meaningful consequences beyond the current maximum 90 days. I want to talk about, and I appreciate the opposition, the unfavorable to the previous bill, bringing this up. The committee did some work on this area, but we know it's not working because we have the situation with Tamika Good in Montgomery County. And this gap was highlighted by the situation. She was a squatter who took possession of a $2.3 million home in Bethesda, Maryland. Good was charged with multiple offenses, including burglary and trespassing. On January 22nd of this year, she was found guilty on all charges of burglary and breaking and entering. However, despite occupying the home for more than 9 months, the court was only able to impose a maximum sentence of 90 days in jail and a $500 fine because the counterfeit lease she possessed is not currently treated as a felony. Subsequently, 1 week later, she was released and moved right back into the exact same home a week later, forcing law enforcement to once again intervene, resulting in a second arrest and conviction. Guess what? Very likely in a week, she'll be right back in that same home again. This is the issue with our laws right now. It ultimately took a 19-year-old neighbor to pursue legal action and help bring this case to justice, at least temporarily. In the meantime, neighbors reported a lot of disturbances, a lot of issues at the home. And this is not an isolated issue. There are websites openly selling squatters' leases. So there are Facebook pages on pages on all different social media platforms, and trying to pass a law to manage them will take years. Right? What's happened is people go online and they post, hey, this home is unoccupied. You give me $2,000, I will set you up there. It'll take at least 6 to 9 months for them to evict you unless you do cash for keys and ask for 10 grand. Well, cash for keys is a program where, and this is gonna be a great hearing, where I basically say, I will move out on my own without having to go through the process if you give me $10,000. And these folks are literally advertising. So now, the entire industry is upside down. So, and she's making a profit off selling other people's real property and allow people to set up there for multiple months. I'm sorry, I only have 3 minutes to go through the whole thing. With that, I urge favorable report.
Thank you. There's several other favorable witnesses. Let me call them. Aaron Greenfield, Ari Elias Bachrach, Matthew Fullerton, and Ian Chen.
There you go. Nice to meet you. Thank you.
Okay, who wants to be first? Why don't we start here?
Okay. Good afternoon, and thank you for having me. My name is Ari Elias Bachrach. I rehab houses here in Maryland. I usually work on very rundown houses. I buy the board ups, the shells, the things with collapsed roofs and no utility services. I can tell you in the winter of 2025, I bought a house in Baltimore near Druid Hill Park. It was a great neighborhood, and this was, exactly my kind of house. It was boarded up, it had no water service. The electric consisted of some scraps of knob and tube wiring. The roof was collapsed, water damage everywhere, filled with trash. And I spent a long time and a lot of money rehabbing it. I got the trash out, worked with BG&E to get new electric connections, new sewer and water connections, new plumbing, new electric, new ductwork, new drywall, new kitchens, everything. Finally got the final UNO in the fall of 2025 and was wrapping up the final work when someone broke in. Someone broke in. I had a security alarm in place. The security alarm went off. The police were called, the police showed up, and the person who was in there knew exactly what to say to the police officer, had exactly the right fake documents to show the police officer. Police officers couldn't remove her from the house. I was on the phone begging the police to remove them. They just wouldn't do it. They said it's a civil matter. I had to go downtown, file a writ of wrongful detainer. It took about 3 months to get the squatters out. In those 3 months, they ended up costing me about $13,000. And honestly, it could have been even worse. I mean, I've seen other squatter houses where they've Poor people have punched holes in every wall, broken light fixtures, smoke detectors, poured cement down the drain, and done, and left behind hypodermic needles and waste and all sorts of stuff. I can tell you it's a topic of constant discussion in all the real estate and rehabber forums. Everyone from realtors to rehabbers to fix and flippers all have to deal with this. We all know it's an issue. We all have to guard against it. And everyone's got a story about how it's happened. There's even people, as the delegate said a few minutes ago online, who sell squatter houses and provide the fake documents that people will need to avoid getting kicked out by police. They're taking advantage of a loophole in the law, and I support this bill because I think we need to close that loophole.
All right,
Thank
thank you. You're next, sir.
Awesome. Thank you so much, Madam Chair. Good afternoon. My name is Ian Chen. I'm a 19-year-old government student at the College of William and Mary and a lifelong Maryland resident. I never imagined that I'd be speaking before you to ask this committee to protect our families in Maryland and our communities. But House Bill 765 will do that. On July 9th, 2025, Tamika Good entered the house next door to my childhood home at 8605 Burning Tree Road and began what would become a 9-month-long squatting occupation. She was not a tenant. She was not a buyer. She had no lawful, legitimate claim to this property. And from that day forward, our community changed. It was only after I took matters into my own hands and brought a multi-count trespassing and burglary case before Maryland District Court Commissioner's Office that she was finally charged and eventually convicted. But that process took time, effort, and energy that nobody should have to expend. The system did not work the way it should have. It required private citizens to push forward what should have been a clear enforcement action. Tamika Good portrays herself as a pro se litigation coach. Despite not being a lawyer, she is seen giving legal advice to followers on short-form TikTok videos and one-on-one guidance to supported clients. So-called pro se litigation coaches like herself sell fake leases to justify squatting in bank-it or bank-owned homes. They exploit gaps in the law, and they understand that when they present a piece of paper that says lease on it to the police, they will do nothing. Right now, law enforcement officers are placed in an impossible position. They arrive on the scene, one party says this is my property, the other produces a lease, and they leave without anyone doing anything. This delay is not neutral. It benefits the squatters, it rewards deception with rent-free living, and it imposes costs on innocent property owners, lenders, and the community at large. I ask that this committee support and give a favorable recommendation to House Bill 765. Thank you.
Thank you. You may proceed, sir.
Thank you, Madam Chair and committee. My name is Matthew Fullerton. Much like Ari, I'm a landlord. I rehab houses. We buy houses. We own 39 homes plus a mobile home park. Big part of our business is buying distressed properties, renovating them, and renting them below market because there is a dearth, as many of you probably already know, of affordable rentals, affordable housing, period, here in our state. I'm in support of Maryland House Bill 765 for the same reasons these gentlemen are, and I actually have personal experience with this. We purchased a home from a distressed seller who was going into foreclosure, was going to lose the house. House was in bad condition. It was in Clinton, Maryland. And the seller had a distant relative who had found out that she was selling the house, and the day before settlement broke into the house and using one of the Facebook fake lease sites, had a fake lease created for the house. So when my contractors got there the next day, he said, hey, he had already started using the dumpster we put there for himself. He said, hey, you can't come in. This is my house. I have a lease here. Police wouldn't do anything. He said, hey, it's a civil matter. We had to file a wrongful detainer. I wish it took 3 months, but he was an older gentleman, and he engaged the Adult Protective Services the day before the court date each time, and extended and extended and extended. So it took 9 months to get him evicted from the house, during which time he ruined the plumbing. He made the house much worse than it already had been. Another point I want to make is that this action doesn't just hurt landlords like me. It hurts the prospective tenants. You have people who are often in desperate situations that buy these leases. They pay, every dime they have. We have seen several, in this case, he paid $1,500 to a person to create this. So they pay $1,500, it's first month's rent, they get a lease created, they move into the house and they end up with criminal charges. They end up getting evicted. They end up getting put back on the street. And a misdemeanor just doesn't do it.
Thank you. Questions for this panel? Delegate McComas.
Just a question, and I know I don't think anybody on the panels are attorneys, but it seems to me that Ms. Good and some of these folks that are doing this are basically practicing law without a license. And I don't know what the penalty is, but that's like a big no-no. And I'm wondering why maybe the Attorney General or somebody hasn't gone after them on this issue.
I mean, it's a tremendous question, and it's created an underground economy, not just of selling other people's real property off from under them, not only selling illegal legal services, but now some of these homeowners are actually hiring gang members to go in, move in with the squatters to force them out. That's what's happening. Whether you believe this is a property rights issue or a right to housing issue, no one has a right to someone else's home, right? And that's the biggest issue we're facing right now. So it's created an entire underground black market economy skirting the law.
And if I could just add, Madam Delegate, I did file a report with the Office of Bar Counsel and the Attorney Grievance Commission to report Ms. Good for her unauthorized practice of law, but I have not had any movement or any updates on that investigation.
Okay, Delegate Conaway.
Thank you, Delegate and panel, for coming in to testify. So Delegate, you said that this is sometimes a cash for keys type of.
So what happens is there's several individuals, one individual specifically, that will post online saying, hey, there's this house available, give me $1,500, $2,000. You'll be able to live there. I'll give you all the documents. You'll be able to live there for at least 6 to 9 months because of Maryland law will allow you to skirt the law to that point. And the worst case scenario, you could leverage up to $10,000 to move out right away. And I can give you guys screenshots of these posts. There are hundreds of posts like this.
So
these people are making millions of dollars off this.
Right. So if you did the cash for keys, would that be a type of extortion?
It's absolutely extortion, and they promote it as such.
We paid it twice.
So, can we say that?
We've paid cash for keys twice in the last 3 years. Neither time has been $10,000. One time was $3,500. Another time was $6,000.
Okay. And
So just to get a squatter, it's easier. Frankly, it's easier to pay to pay them to get them to move out than go through the entire process that it takes and watch your home be devalued by 10 times the amount that you're paying.
Okay, so the process is described as taking maybe 10 days, and then shortly thereafter, you'll be able to get the squatter or whatever evicted. Do you find that to be accurate?
What we've done is literally handed them a check, sort of as they're walking out the door and taking the keys, taking possession of the house from them. We wouldn't give them money in extended time.
He's asking, they're saying the process only takes 10 days to evict somebody. Can you explain why it's not that?
Oh, the reason it's not 10 days to evict somebody is because there's loopholes everywhere. Like just in my situation, they engaged adult protective services, delayed court hearings. He said he was infirmed. He said he was mentally unstable. He can come up with any reason in the book. And then additionally, even if you do file the wrongful detainer and get you to your court date in 10 business days. We've seen people say, hey, the weather, we can't evict. Hey, we can't evict for this reason. And it takes weeks to schedule evictions with your county. So like I live in Calvert County. Each county is different, but it can take weeks and weeks and weeks just to get an eviction on the books, or months. So during that time, these people are still occupying the house and can find more loopholes.
And make no mistake about it, this is sophisticated because the individual selling these services is coaching these individuals up on how to manipulate the system. So it's not just somebody who rolls in some house and move in. They have these, fake attorneys who know just enough about the law to help people navigate this. So these guys are prepared, they're smart, they know what they're doing, and they know all the loopholes. So this at least raises the consequences to make it less attractive to skirt those loopholes.
Thank you so very much.
All right. Delegate Woods. I'm sorry. Delegate Woods.
Thank you, Madam Chair. Mine is help me understand. These people present a fake lease. Who signed the lease?
So it's way worse than that. What happens is there's one woman who's the most notorious person in the scheme. What she does, she goes online, she has multiple profiles on social media, and she also does like credit cards, she does other scams too, but this is the one affecting real property. She will post online pictures of a house she's aware that is currently vacant, whether it's in the process of being sold, whatever reason it's vacant. So she identifies this vacant property. She will post online, say, hey, I have a property for you. You pay me $2,000 now. I will provide you, and she forges all the documents. And so when law enforcement shows up and sees forged documents, law enforcement is not qualified to identify these documents are forged. They just see a signed lease and they have to take it at the word, right? So, I'm sorry.
I'm sorry, my question is she forging the signature of the homeowner?
No, she's creating a whole new lease.
So how can that be, if I'm the homeowner and somebody presents a lease that doesn't have my signature as leasing it to them, why is that not enough or grounds for an officer to say, well, you're going to have to leave until this is figured out?
Well, because the officer showing up, and correct me if I'm wrong, doesn't have the resources or the expertise to verify who the homeowner is.
They're also terrified of making a mistake, being accused of, abusing, racial profiling, all different kinds of things. So officers show up. It's hard for a police officer just driving up to a house to say, hey, here's who the owner is. Does this signature match? Does this match? They're being presented with a lease that looks official, and they don't know any better, and it's better to err on the side of caution rather than to kick someone out of a house that they could be doing wrongfully. So they always 100% of the time say it's a civil matter and don't take any.
And then when I look at the sum total of the issues, the other bill I had in this committee that would force judges to recognize the signed contract in court as ownership of real property, because in some cases it takes 2 to 6 months to record that deed and land records. Even if they have a signed lease, there's no way to confirm that's the owner. And that's only situations with residential. With individuals who are landlords, that might be in the LLC. And that's even tougher for law enforcement to differentiate. So it's just, there are a lot of loopholes in our laws that have created this. We need to work together as a body to start closing these loopholes.
Thank you, Madam Chair.
All right, Delegate Taylor.
Thank you, Madam Chair. I know this is a problem. I had a squatter in my neighborhood as well some years ago. I actually have a bill right now that would use the blockchain to as the platform to hold as the database for home ownership records. So the blockchain is immutable, it's irrefutable, you can't change it. So if it's there, it's there. Police would be able to just make it, they would see exactly who the homeowner is, and we'd have that decision made right there. So Baltimore City has a pilot right now that's doing something very similar. But that's not my question. My question is, actually it's a concern and a question. And I know Camp Springs and Prince George's, I represent, not Camp Springs, but Prince George's. And that area sometimes tends to be aging. So there may be an 85-year-old who owns a home there, a 90-year-old, sometimes even a 100-year-old who may have died. There's some situation. I just wonder, in the case in Camp Springs, or Clinton.
Clinton, yes, ma'am, Clinton.
In Clinton, this person who moved in because it was a family member. And I know sometimes family members are trying to save the house that belonged in their family for years.
Sure.
I don't know if this is the case with you, but just wondering, could you just elaborate and can we just rule out that this was kind of the situation there?
A little more detail? Sure, yeah, absolutely. So the seller this was a distant relative, they hadn't been in communication for years. This seller, they had found out secondhand from another relative, this was either a first or second cousin, I can't remember. They had heard from the seller's sister, who was still in touch with them, that she was moving out of the house, and a general idea of when. They were in and out, from my understanding is that they were in and out of, living arrangements with friends, things like that, didn't have a lease. So they, forced entry into the house as a means of, hey, this is a place to live and it's going to be free. And I know how to do it. And they looked up on Facebook, and this person was, I said they engaged the, Adult Protective Services, but they were only 59 years old. I mean, so we're not talking about an 85 or 100-year-old person. We're talking about someone who's not even, elderly. If 59 is elderly, then I'm in trouble.
Me too, sir.
So no, it wasn't a situation where they were trying to save a house. It was a situation where they were just trying to find a place to live. And I mean, not to get into too much detail, but their water service water service wasn't on when the house had been winterized when this had happened. So this person used the bathtub to defecate and everything for a period of a couple months. And then they didn't take care. They destroyed the plumbing that was there, trying to bring it to work. They destroyed the electric. It was someone who just took advantage of an opportunity that they saw, and they used Facebook Marketplace to find someone. I don't know if it was the same person we're referencing here, but someone helped them create a lease and get it signed and everything, and it was good enough for PG County Police.
Thank you.
No problem.
Delegate Conaway?
Thank you, Delegate, and people for coming in to testify. Did law enforcement get the legal names of the wrongful detainers when they were called? Any of you two that have experience with?
Yeah, I believe they did. I don't have any of that information with me.
Report or anything?
No report. I didn't get a police report or anything like that.
Yeah, I can tell you in my case, yes, they did get the names of the people in there because the squatter also moved in with her children. They wouldn't release the report to me because they were minors. I did eventually manage to get a redacted copy of the report, but it definitely took a long time. And ultimately, there simply were no consequences.
Okay, thank you so very much.
Delegate Moreno? I'm sorry, Delegate Mangione. Delegate Mangione, and I know your name. Sorry about that.
No, all good. Thank you, Madam Chair, and thank you for the bill, Delegate. I just want to make sure I'm understanding correctly. So currently, and I may have missed this, if I'm sorry, I apologize, I did. It's very difficult, I guess, to get some type of conviction or prosecution or to really punish somebody that may commit this type of fraud now because I guess it's more broad in how they're going after these people.
Well,
and
the penalties are so low.
They're so low.
And raising the penalties is not designed to put more people into the criminal justice system. It's designed as a deterrent because they know, like with Tamika Good, she can move right back in the same house a week later because the penalties are almost nothing, right? So by raising the penalties, hopefully Tamika Good would reconsider doing it again. Where right now, she's been arrested twice, convicted twice, moved into this place twice, and now in a few days, she's probably going to move back in for a third time.
And I agree with you. I'm wondering, is it also challenging the way it exists now to go after and prosecute? One of the testimonies I was reading is saying that it's kind of broad to when they go after somebody for an individual that's committing fraud with a lease.
Well, that's right. That goes back to because there's a lot of counterfeit and forged leases and rental agreements. Law enforcement, when they show up to consider a civil matter for a variety of reasons, there's lots of ways to push the court date back by using loopholes in the system and work in the system. There are people being paid to advise them on how to do these things. So it's an elaborate scheme that's now a multi-million-dollar underground market here in the state of Maryland.
Thank you. Thank you, Madam Chair.
Thank you, Delegate Mangione. Delegate Valentine.
Thank you, Madam Chair, and thank you, Delegate, and thank you, panel, for coming in today for this very important topic. My question, I wanted to kind of zero in a little bit more on the manufacturing component. I think you touched on it, Delegate. So you know who these people are, or they're able through some of these cases understand who the individual is that's manufacturing. I'm trying to get more to a higher level. So my intent would be, would you be agreeable if we, not to minimize the possessing part, but I'm concerned about the individuals that have kind of been duped. Okay, that are possessing something they may not have known was fraudulent, more so about the manufacturing. So it's not a problem identifying the individual, maybe start minimizing these incidences more by getting rid of the individuals that are mass producing them at the fraudulent level. But so that's not a problem identifying these individuals?
Well, no, they're blatant. They do not hide. They know they've been reported to state police. They've been reported to the Attorney Generals. The Attorney General is aware of these individuals. Their profiles are not blocked or hidden. You can look right now on your social media, find these individuals. But they advertise the fact that these are vacant homes. They advertise the fact that you can skirt the law for 6 to 9 months. They advise the people that they are selling these homes to or selling these fake leases to that you're breaking the law, that we're going to help you skirt the law, and worst case scenario, you can extort the homeowners. So the people going into these situations know full well what they're doing.
And not just to add to that, if I may, anyone here can go on Google right now and type in, Maryland lease contract and pull up something and fill it out that a police officer is going to take your word for.
Thank you. Thank you, Madam Chair.
Thank you. I had a question, just wanted to make sure. So currently, what is the time period for violators? Was it, somewhere I thought I saw something like 90 days in testimony or something?
Doing time period of violators in terms of the time they get charged?
Yes, yes. Oh, if you don't have that information, it's okay.
I don't have that. I don't have that in front of me. But what I know is the Tamika Good situation.
Yeah. So Ms. Good got 90 days.
She got 90 days and was released in just a few days.
Yes.
And a week after the conviction, moved right back in the same house.
Yes. And so you are proposing what time frame?
What we're
3
proposing
years, is that correct?
To raise to a
3
felony,
years.
yes.
Okay, I just wanted to make sure I understood. The reason why I was asking is because, we have adverse possession law, and where you can actually take over someone's house, but usually that's been like 15 or 20 years where the owner's not doing anything. So are we speaking of, in doing this, in this bill, and I don't see it, but I just wanted to put it on the record, are we speaking of any time frame or any time frame that is not your house, essentially is a problem? Would you agree?
Yes, because you're stealing somebody's property.
Right, okay. So I just wanted to, I think of adverse possession when I see this bill, and I just keep wondering why it's only just 90 days on the books right now. I guess people weren't doing it before.
Well, squatter's always been an issue, but a very small issue because it was usually individuals that are opportunistic, right? It's become a business.
Right.
With these individuals selling the services, the legal services, legal advice on how to extort individuals, legal advice on how to pull loopholes. And Madam Chair, the gentleman to my right, Matt, kind of testified a little bit to the individuals that he had. It took 9 months to even get into the courtroom because of individuals leveraging different loopholes, being advised by these individuals, selling these services, forging leases, giving legal advice, and helping them learn how to extort the homeowners.
Right. So openly teaching people how to extort. Okay, thank you very much. Members, do we have any other questions? The Vice Chair?
Thank you. My question is for Mr. Chen. You spoke about the house next door is where the issue was, and that you were able to help get the squatters out.
Yeah, that's correct.
So I'm concerned about your standing to help get someone out of someone else's house.
That's a fair concern. I volunteered myself and my help and my knowledge of the law to the realtor of the house. The house is bank owned. Previous owners were foreclosed on. He appointed me an agent of his firm to then go post notices on the door. And then eventually Tamika Good sued me for a peace order. And that's how we kind of got started here. But I had permission this entire time to post these signs, to file charges, to do anything and everything to secure this home in a lawful and appropriate way so that the actual and legitimate buyers could come in and take possession of the home that they paid for.
Okay, and how long did it take?
It took about 9 months of her living in there. She filed for bankruptcy multiple times. She called the court once and said that she was going to the hospital for chest pain. She used basically every tactic in the book to prolong her occupation as long as possible.
Okay, thank you.
Thank you.
Thank you, members. Delegate Phelps?
Thank you, Madam Chair. I just want to make sure that an unknowing, and it says knowing, but an unknowing individual would not get caught up in this if they happen to possess this lease. So I could have an individual who was nefarious, created the lease, got engaged with someone who was not knowing, needed a place to stay, had this lease. How do we ensure that that individual doesn't get caught up in this web?
I mean, I guess the question is, could one of these individuals simply post on Facebook Marketplace, hey, monthly rent, this, that, and the other, blah, blah, blah. Sure, absolutely. But that's not what we're seeing. And there's always, again, there's always a chance someone may unknowingly squat in someone's house, may unknowingly get a false lease, may unknowingly get these things. But the business of this is not that. These social media sites are very, and I can give you hundreds, if not thousands of screenshots of multiple posts where it's very blatant in what they're selling, what they're advertising. And that's the issue we got to deal with. So, and again, that's where the judicial system comes into place, where if this goes before a judge, then a judge can adjudicate whether or not this person did it knowingly. And if the person said, well, hey, here's the Facebook post I responded to, it told me they owned the property and they didn't know any better. But if, unfortunately, as in the overwhelming majority of cases, that Facebook post actually explicitly says what you're getting into.
Delegate McComas.
Thank you, Madam Chair. Have you received any assistance or help from the Attorney General's office? They have over 500 attorneys. And it seems to me that this is really serious because of a lot of people, their biggest asset is their home. And I guess I'm like, wow. It really boggles the mind. And then the fact that there's deeds that people are losing their house because of deed transfers that are fraudulent. I mean, I just think if this was in the banking system or we were ripping off savings accounts or checking accounts, there'd be a little bit more fire around here.
I mean,
I congratulate you for doing this, but I think it's, you should have the aid of the state.
Again, the main kingpins responsible for this have been referred to the AG's office multiple times, and unfortunately, the most notorious person, the only charges brought against her to date was assault of a reporter.
And Madam Delegate, I also, in my case, asked the Attorney General's office multiple times to step in, and despite writing them numerous letters, they never responded or offered any assistance.
Did any prosecutor, any state attorney's office ever prosecute for any other crime?
Only for trespassing and burglary. That's it.
Okay. Okay, thank you. Are there any other questions, members? Delegate Phillip?
Sorry. And you seem to be very knowledgeable because it seems like you've very much gotten into the weeds with this. Couldn't these individuals be prosecuted for fraud?
Can I take that? Again, it goes back to the heart of the bill, because having counterfeited these documents is not a felony. So it's a misdemeanor, right? And in some cases, apparently, I guess state attorneys aren't choosing to charge them with that misdemeanor.
Counterfeiting documents could be considered fraud.
But I'm saying, but under the law, and I've worked very closely, so Senator Ron Watson's my cross-file on this bill. We worked very closely on this. Again, maybe it could be, but under the statute, counterfeiting and forging these documents and being in possession of them is not a felony.
The Vice Chair.
Mr. Chin again. You said that they could be prosecuted for trespassing and burglary.
Yes.
Has that happened in either of these cases?
Yes. So she was originally convicted of multiple counts of trespassing and fourth-degree burglary in a district court trial on January 22nd, but she's actually since appealed that case to the circuit court. She was released on a $5,000 appeal bond, and that same day she was released, she moved back into the home and began her occupation once again.
Okay, thank you.
Thank you.
All right, members, not seeing any further questions, that concludes this panel for House Bill 765.
Thank you, committee. Thank you, Madam Chair.
We're going to move on to our unfavorable testimony. Albert Turner. Hi, Mr. Turner.
Good afternoon.
You have 2 minutes.
Thank you. Chair, Vice Chair, Albert Turner, the Public Justice Center, asking for an unfavorable report. We really respect the delegate's intention on this. We really understand the issues that have befallen Maryland in this regard. However, as some delegates have noted, we believe this bill to be overly broad, particularly when it comes to folk who have been scammed. I will relay you a client that I had last year who testified in front of this committee about the wrongful detainer bill. She was a victim of domestic violence. She was looking to find a place as soon as possible. She found a place on Craigslist that allowed her to move in the next day, which obviously was really important for her. She was able to move. First month's security deposit, moved in, everything was lockbox, everything was electronic. She got the lease through email. She printed it out. She had correspondences through WhatsApp, and she moved in. 2 weeks later, someone came to her door saying, "What are you doing here? You don't live here." She got scammed. Now, when she came back and I tried to talk to her, the Craigslist post was gone. The WhatsApp notes were wiped clean. The only thing that she had was this fraudulent lease. And under this bill, she could be prosecuted for possessing a fraudulent lease, even though that was not her intent, and because she had no evidence to prove otherwise. And so because of that, we believe this bill to be overly broad. We also believe that for the purposes of ringing in leaders who are, teasing, I will allow you to sign a fake lease, or I will teach you how to do this. These are things that we believe that places like Facebook, Craigslist, Instagram need to be held accountable for. They're allowing someone to go on their databases and websites and say, "I'm going to commit a crime. Let's come do this together." And so as my stated, Delegate Embry has a bill that we fully support that looks to curb these social media companies from allowing these type of criminal behavior to happen. And we ask for an unfavorable report in that matter. Thank you.
Thank you. Delegate Ericon, you have a question?
Yes, ma'am. Thank you so much, Madam Chair, and thanks for being here. What if we tweaked it a little bit and we made sure that we included intent? So that we could avoid criminalizing your client, maybe we could have something that specifically says that they were in possession of a fraudulent document with the intent to defraud, something like that.
Yeah, forgive me if am I incorrect. I believe the intent is already in the bill. I might have already, I might have missed that. That might have been the Senate side. I do know that for the purposes of my client, like I stated, how would she defend herself proving that she didn't intend to have this lease? The only thing that she has is this fake lease. She has no communication with the person who scammed her. The person that scammed her is long gone. The posting that was on Craigslist is long gone. The WhatsApp correspondences that she had is wiped clean. She has no evidence to prove otherwise that she did not intend to possess. And so I think possession is very different from, giving someone, right? Or I'm gonna sell you this online. Very different from the actual possession. And that is the issue that we're seeing. People who are possessing with no intent to, but unable to prove otherwise.
Okay, well, I mean, I guess the way, if I was her lawyer, I guess maybe I would provide the fact that her laptop didn't have any of the rough copies. You know what I mean? Like she did not create the document, so somebody else created the document. She may be able to prove it was emailed to her, sent to her. Do you know what I'm talking?
No, it was emailed to her, and
Okay.
it was, "This is the lease." Didn't say anything otherwise.
Right.
Is that going to be enough to say that she didn't intend to? I mean, it could have been, prosecutors say, "Well, that's a co-conspirator," right? That was someone giving you the lease and giving you authority to defraud the person, right? There was nothing else aside from that to prove otherwise.
Okay, this may be a very, very specific case, but there's a lot of stuff, now that I see the old language on here, bond, check, deed, draft, there's a lot of stuff here that I guess my point is, right now, this law is good enough for those things, and the intent piece of it is good enough for these things. And I'm just trying to understand why would it then not be good enough for a lease? These are obviously things that people would have to defend in court. You got to mount a defense, but I don't know. But thank you. I appreciate you going back and forth.
And I think to the extent our biggest concern in this is retaliatory landlords in this way, where a tenant is living in a building, they have a legal lease, and a landlord who, for whatever reason, wants to retaliate can go to the cops and say, "This person has a fake lease." And the cops come and, whatever, "I didn't give this person a lease. I don't know who this person is." They might come and they arrest the person, right? Or they might file charges against them. And by the time that they're able to come there, They might have a criminal record, they might have to go get a lawyer.
Okay.
It mixes up the whole issue. So that's kind of the
Yeah, now I
issues that
see
we
a bigger
in that
picture
way.
now. Okay, so what if we included some kind of penalty for a landlord who misuses it?
I mean, I think, and again, in our written testimony, I think, at least, I don't know if they submitted in the House, but in the Senate side, the Office of Public Defender also noted these are already crimes, right? This is already something that can be prosecuted. A landlord who is alleging, falsity against someone is a crime. A tenant who is fraudulent, creating fake leases, that's already a crime. These are already crimes under Title 8 of the Criminal Code, which is kind of why we believe this bill, doesn't apply and overly broad and superfluous a little bit.
Okay, but we can agree there is a problem going
Absolutely,
on. Okay.
absolutely.
All right, thank you. Thank you, Madam Chair.
Thank you. Delegate Cardin.
Thank you, Madam Chair. Thank you very much for coming.
Thank you.
So first of all, going back to the discussion you were just having, if the state's attorney would not necessarily be required to charge them with a felony counterfeit if they determine that this person in fact, didn't have the intent. Isn't that true?
That is absolutely correct. However, they could, even if there's,
In your scenario, you also, there was somebody who countersigned it. There's no way to find that person, or did they fraudulently put the actual owner's name on there?
Yes. Because it's on SDAT, right? Everything is, you can usually find in public records or on SDAT. Scammers, and I've seen them, right? You go on TikTok, you go on Instagram, Craigslist. It'll just be someone who's broken into a property, showing video of the unit, taking pictures of the unit, acting as if it is their unit to lease out. And my client, she had a lease that was signed by the owner. I confirmed it on SDAT. The guy was like, I didn't intend to lease this at all. All these other things are here, right? And so there's no way to mitigate or at least show a prosecutor I didn't intend to fraudulently possess this lease. And I think that's the issue, is just the intent to possess a fraudulent lease. If you can't go against that, that's really difficult for our clients.
As we've learned, and I'm sure you've learned in court, it's really, really difficult to prove intent. And this would be a criminal matter. So beyond a reasonable doubt, the other side would have to prove that it was her intent to do this, to commit this fraud. And so you're actually, you're suggesting that she's already guilty and then she's going to be found guilty. I think that's not the case.
Well, maybe not, but I think when we're talking about criminal cases or, enhancing criminal penalties, we're also talking about what it takes to get to trial date, right? So in my case, my client, if she had been charged with criminal matter, that would have been on her record. She might have gotten to either pay or get a public defender in that way. And the stress of that is incredibly, incredibly hard, right? And so the process of actually going through a criminal defense for this matter versus I come out on top, maybe or maybe not, I've seen criminal cases where, landlord says, I didn't lease this person, this to anyone. I don't know anyone else. Defendant comes in and says, I didn't sign this lease, and there's still a guilty verdict.
All right. So did the landlord actually ask your client to leave and show her that she was not the legitimate?
They filed a wrongful detainer against her.
Okay.
Yeah.
And then she left.
And she vacated. She did.
So there was no criminal matter that was ever filed against her.
No, because
wouldn't that be the case in 100% of the time? They would try and get the person out immediately. If they left, there wouldn't be an ability to file a criminal matter against them.
I mean, I can't speculate as to what that would look like. I could say that we see retaliatory landlords all the time, and they use every single thing in the book to try to, either get the tenant out, to get get revenge on them for whatever reason, and for the purposes of just passing another law that might rope in our clients. That's our opposition to it.
The last question. So, as the folks on the other side already testified to, you can charge, basically right now you can charge burglary, you can charge trespass, I guess you can charge perhaps fraud and misdemeanor counterfeit. Each of those could be up to 90 days for the first time and then 2 years for the second or third time, particularly on the trespass. I think burglary, actually, if you got a third-degree burglary, which you could be 3 years. So if a judge, so is the issue, I would assume that the issue that you're making is that judges already have the ability to put people away for over a year or more, even on a first time, based on a consecutive sentences?
I mean, our argument is that there are multiple ways that a prosecutor and a judge can go about this. Our main issue with this bill is the actual possession, right? Because, as I stated, a person can possess, and because of the way the framework of the internet is and, you know, scamming is, they're unable to come up with a defense that they intended to actually possess the lease for the purposes of fraud, right? And that's our main issue, is the actual possession with intent.
So there's two different
hard to defend.
There's two different counterfeit charges. There's counterfeit and then possession of counterfeit. So you're saying if you got rid of the possession of counterfeit and just kept the counterfeit, you would be okay with that?
I would talk about that, Delegate. I don't want to commit at this point right now, but I think that that's something that we might be able to be open to.
Thank you, Madam Chair.
Thank you. Members, do we have any further questions? Seeing none, that concludes our testimony for House Bill 765. We're going to move on to Delegate Rosenberg, House Bill 750. Delegate Rosenberg, do you have Joshua Stevens, Sarah Mikey? I know I messed up your. That's everyone that I have. Okay.
Thank you.
Whenever you're ready, Del.
Thank you, Madam Chair and members of the Judiciary Committee. Hate crimes are growing at an alarming rate in our state and across the country. And hate crimes, I think, are an appropriate precedent for House Bill 750, which would add an offense for intentionally preventing someone from entering or exiting a religious facility, as defined in the bill, religious facility, which is what the hate crimes law does. We made a policy judgment then that criminal acts motivated by enmity towards the victim, if the victim is a member of a certain category, merits an additional offense and thus an additional penalty. And over the years, this committee has added to the list of characteristics, identifying factors that can prompt a hate crimes offense. What we've done in this bill with the growing incidence of hate crimes against religious facilities is to use the language from existing law so that we are defining religious facility as it is defined in the hate crimes law. There, though, the law deals only with destruction or damage to the facility. Here it deals with preventing an individual from entering or exiting a facility when the action being taken by the offender is not protected by the First Amendment. The more recent statute that we draw upon in this bill is that which was passed a little more than a decade ago, again by this committee, as obviously was the hate crimes law, to make it an offense to prevent someone from entering or exiting a medical facility. What prompted that bill? There was a growing instance of demonstrations against reproductive health care, against abortions, and we drafted a bill, we enacted a bill consistent with the First Amendment. There have been, to my knowledge, no objections raised to this law since then. We use the same language here, where you're trying to prevent someone from entering or exiting a medical facility more broadly than just because of reproductive health care. I would also add that this bill saves money for the state in that the state currently provides $10 million to religious facilities to provide preventive self-defense physical measures to make the facility safer than it would be otherwise. As an example, the new Jewish Community Center, which happens to be in my district on Park Heights Avenue, the cost for the entrance, the security in the construction at the entrance is significantly greater than it would be otherwise because of the safety and security measures that needed to be taken.
Thank you.
Thank you for all those reasons.
Whoever is ready to go next, Joshua or Sarah?
Sure. Good afternoon, Madam Chair, Madam Vice Chair. My name is Josh Stevens. I'm the Deputy Regional Director for the Anti-Defamation League. I cover the Washington, D.C. region, covering Maryland, Virginia, Washington, D.C., and North Carolina. On behalf of ADL and of a Jewish citizen of Maryland, I strongly support House Bill 750, which, as the delegate said, it prohibits the interference of access and egress from Jewish facilities. Part of my job, every anti-Semitic incident that comes up in this region comes across my desk. 2024 was the sixth largest, Maryland was the sixth state in the country for anti-Semitic incidents reported. Of those 256, over 60 of them were in Jewish institutions and religious institutions. And what this bill does, and we don't see that changing into the next year, even though we haven't released our data. And with 3,003 faith-based incidents reported by the FBI also in 2024, we see a need to protect our religious institutions, specifically who are being targeted. We saw it in Mississippi, we saw it in New York, we saw it in Olney last week in Share Torah. So this bill does a lot in providing crucial measures to provide that safe access. But what it doesn't do, it doesn't infringe on protected rights of freedom of speech. It doesn't prohibit protesting. It prohibits blocking people from entering and exiting. Very similar incidents that we've seen on college campuses with school buildings. We can't have people being prevented from accessing this. So I think this bill goes a really long distance in both protecting the basic constitutional rights of freedom of speech while also giving people like me, my children, my family, and my peers from going to shul and going to synagogue, and really all people of all religions. This is not specific to synagogues, to shuls, and it does extend to cemeteries and other aspects of it. So we strongly urge you to provide a favorable report for House Bill 750. Thank you so much.
Thank you. Sarah?
Good afternoon, Chair Bartlett, Vice Chair Davis. My name is Sarah Mirsky-Mickey. I'm the Deputy Director of the Baltimore Jewish Council, which represents the Associated Jewish Community Federation of Baltimore and all its agencies, here today in support of HB 750. As the delegate explained, this bill makes it a misdemeanor to interfere with the access to a religious facility without infringing on free speech. The time is now. Years ago, you passed the medical facilities bill because people were scared of being physically barred from entering medical facilities. Today, religious facilities are facing these same threats, whether it's students trying to go to Shabbat dinner on Hillel on campus, or for people to go to services on the weekends for Shabbat. They are scared. They are scared because this is actually happening, whether the events in the fall in New York and Los Angeles where people were unable to pass in order to get into their synagogues, or where kids on campus, again, are unable to get into the Hillels for those programs. Unfortunately, these incidents are not going away. And as the state showed many years ago for the medical facilities for a need to have this type of crime, we're asking for a favorable report for religious institutions. That's why we're asking for a report on HB 750. Thank you.
Thank you. I was looking up something really quickly. Are any of you all familiar with the Westboro Baptist Church case where the Supreme Court stated that people had a right to protest at a funeral? So this bill does not run afoul of that because the First Amendment rights are being maintained. Do you agree, Delegate Rosenberg?
I seem to recall that Westboro took place when we were considering the law dealing with medical facilities. If I remember correctly, counsel probably has a better memory than I do, but I think the Westboro case was decided in the midst of our consideration of the medical protection law, and therefore we were very clear in making the bill, now the law, consistent with that holding in Westboro.
And just to add, we did add originally to the medical facilities in response to Westboro about obstruction for entering and exit a funeral, burial home, et cetera. So this is kind of like this would be the third iteration, I guess, of the medical, or the second iteration of the medical facilities. And again, it's not about protesting, it's about access to entering.
Right. Thank you very much. Delegate Conaway?
The bill and panel for coming in and testify. Somebody on the panel said cemeteries and now burial homes would be considered as part of this bill?
Burial.
Well, that's current law.
That burial homes, is that a?
Funerals, burial facilities, it's 10205 of the criminal law, obstruction of entry or exit from funerals, burials, et cetera.
It's a cemetery and the grounds adjacent to them. That's the language in the existing law, the existing hate crimes law, that you can't deface the property of a cemetery or the grounds adjacent to the cemetery. And that's the language we use here.
As in interfering with the access or egress from the cemetery or burial place?
Well, if you mean the burial, not the home, not the burial home, but the cemetery, however you want to describe it, and the grounds adjacent to it.
The burial home is the place where they have the ceremony? Is that where you have?
That would not be covered under this bill.
It's covered under current law, though.
Right.
This is like adding, like, that's a sacred place, we shouldn't be doing this. In addition, religious facilities are also sacred places, so we should not be doing this.
Okay, thank you so very much.
Thank you. Delegate Cardin?
Thank you very much for bringing the bill and for your compelling testimony. This is for you, Sarah. So first of all, your offices are, the new offices of the Associated and maybe the Baltimore Jewish Council are in the JCC, right?
In the Park Heights campus.
You're in the Park Heights campus, which is right adjacent to the new JCC building that's just being renovated, or the new renovated building. As I served on the JCC board for many, many years and got a chance to vote on that budget, I can tell you in no uncertain terms that the amount of money put into security on the new entrances was astronomical and was a very, very big point of contention. But because of issues with security, it was important. My question to you is, have you seen firsthand, has the Baltimore Jewish Council and or other constituent agencies, maybe Forefront or Hillel, you can maybe explain a little bit about, for people who aren't as familiar with Jewish campus, organized Jewish student campus programs, whether you have had students come to you and tell you that they've been so upset with not being able to get ingress or egress from a building, they've just chosen not to do it or to avoid those kinds of interactions.
Students have been scared to go for not knowing what they were going to face when they got there.
So if they wanted to go, for example, to lunch in a building, they would just choose not to go because they were afraid of going through a pathway that was going to be confrontational. Yes. If they wanted to go to study hall, they wanted to go to a student event or even an academic event, sometimes they would just avoid it.
At the Hillel, yes.
Thank you.
Thank you very much. Members, Delegate Moreno?
Mangione again. All good, it's all right. No worries, Madam Chair. It's the glasses. I never used to have to wear glasses, but I do now. There we go. But thank you again, Madam Chair, and thank you for the bill. And I absolutely agree with Delegate Cardin in the premise. I mean, there is a lot of anti-Semitism and things like that going on. My only question for learning purposes, why or what happens in a case of like a private business that protesters may have a total disagreement with, where they're doing something similar? How does that work now? And would that be, I mean, I understand the premise here is religion. I'm just trying to understand why a private business wouldn't have the same protection, or they do. It's like obstruction. I guess obstruction deals more with government agencies. I mean, we're seeing a lot of that right now. But, or disorderly conduct, would this not fall under, or I'm just asking you as a legal expert and trying to learn a little bit about it.
Well, I would think if at a minimum, when it's a private business, you would have to demonstrate as the prosecutor that the criminal action was motivated by the faith of the owner of the building or the business that he or she was engaged in.
Well, I guess what my colleague I'm saying is a good point there. Why is this not already covered under some law? Because yes, I guess you're saying on a religious perspective, and I'm not disagreeing with you, I understand that. I'm just wondering, there are a lot of private companies that people do not like, and then they're sitting out in front of that and blocking access to that private company. Why isn't the law the same right now existing?
Well, in the hate crimes law makes it the public policy of the state, and many other states, obviously, that if a criminal act, certain criminal acts are motivated by the race, religion, national origin, sexual orientation, so on, of the victim, then it is a hate crime. So it's enhancing the whole basis of the hate crimes law and of this law is certain acts, there should be an additional penalty available to the prosecutor because of the nature of the motivating factor.
Maybe we all deserve an honorary legal degree for sitting on this committee. I'm learning a lot about the law. Thank you.
Agreed. It's so much worse. All righty. Well, thank you very much, Delegate. That concludes the testimony for House Bill 760. We're going to move on to House Bill 670 with Delegate Mangione. I wanted to see if he was listening. Delegate Moreno. House Bill 670. Don't we all for Delegate Moreno?
Delegate Moreno.
First bill?
First bill, yeah.
First bill ever. Yes. Okay,
it's a good bill.
so I see that we have a panel. Is
Yes.
that? Yes, it is. I can't. Good to see you. Okay, we have Gavin Protasnik, Zachary Payne.
Yes, ma'am.
All right, and Jody Kavanaugh? Yes. Oh, there you are. Okay. Great. Good to see you, Mr. Protasnik.
As well, too, Madam Chair.
All right, Delegate, whenever you're ready.
All right. Good afternoon, Chair Bartlett, Vice Chair Davis, and members of the Judiciary Committee. For the record, I am Delegate Gabriel Moreno, and I am here to ask for a favorable report on House Bill 670, Child Pornography Prohibitions and Penalties. Some of you may be familiar with this piece of legislation. It has been reintroduced from last year and has passed out of the Senate the last 2 years. House Bill 670 modernizes Maryland's state law against child sexual abuse materials to reflect the realities of today's materials, both in form and in scale, and to ensure that our penalties appropriately reflect the severity of harm involved. HB 670 takes on this challenge in two ways. First, the bill clarifies what constitutes possession of child sexual abuse material, CSAM. Under this legislation, possession would separate images depicting a child under the age of 13 or images that are indistinguishable from a child under 13. This includes real photographs as well as videos and computer-generated AI images, which are increasingly being used to evade accountability under current law. This provision should enhance the penalties based on the age of the victim. Currently, Maryland law treats possession of child pornography as a misdemeanor and applies the same penalty structure regardless of whether the child is depicted as a 15-year-old or a 5-year-old. HB 670 changes that. When the image depicts a child under the age of 13, the offense would increase and carry potential incarceration of up to 10 years, as opposed to the maximum of 5 years and a $2,500 fine. This provision is left in place after extensive conversations with law enforcement, state's attorneys, and victims' rights advocates. We must recognize that the younger the child, the greater the harm and exploitation. Second, the bill enhances penalties based on the quantity of material possessed under HB 670, possession of 100 or more images would also trigger the enhanced penalty. A single image is counted as 1 unit of possession, while each video is counted as 20 images. This provision recognizes prosecutorial discretion to batch charge counts rather than requiring individual charges for every image. In doing so, it relieves the state's attorneys of the unnecessary burden of reviewing countless pieces of child sexual abuse material, work that is both operationally inefficient and emotionally taxing. We are not married to this numerical formula and would be open to amendments, but the intent is that possessing hundreds of images is categorically different from possessing one. Additionally, other states have established their own numerical precedents for counting images that equate to a video, and most of these states have a lower threshold than this bill contains. Finally, I would like to vote that we are working with Maryland State Police to gather research on this issue. MSP remains neutral and is not taking a stance on this bill. Data shared from MSP demonstrates both the scope and escalation of the problem, rebutting any suggestion that heightened penalties lack necessity. Maryland cyber tips increased dramatically from 13,000 in 2024 to over 21,000 in 2025, indicating not only a prevalence but a growth. The Maryland ICAC task force made 279 arrests in 2025 alone, with investigators reporting that at least half of the reviewed cases contain thousands of images. This volume-based harm is precisely why this habit is tied to image quantity are rational. Greater quantities correlate to deeper engagement, broader distribution network, and increased re-victimization. For these reasons, I request a favorable report.
Thank you.
Yeah.
Whoever is ready for next.
I'll go next. Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Gavin Potashnik. I am the chief of the Special Victims Unit of the Cecil County State's Attorney's Office. I'm here on behalf of that entity, as well as the Maryland State's Attorneys Association, asking for a favorable report on House Bill 670. I thank Delegate Moreno for his leadership and most importantly for his understanding of the issue. I've been a prosecutor for something like 18 years, and when I'm not doing juvenile, I mostly do special victims work. And one of the worst types of crimes that we prosecute ever is the possession and distribution of child pornography. Members of the committee, in the past 10 years, I have seen a dramatic increase in both the quantity and the quality of the child pornographic images, which are now essentially all over the internet. The collectors of this type of material is not trading in what used to be Polaroid images or in singular images, but thousands and thousands and thousands of images, and we can't keep up. We need to update the law to make sure that we have the tools necessary to prosecute collectors of child pornographic material appropriately with a 10-year felony sentence when you're in possession of 100 or more images, or if you're in possession of an image where the individual subject is under the age of 13. Because there is a huge difference between, and all child pornography is bad, I'll say that at the start, but there is now child pornography where we have infants. I'm prosecuting a case right now where somebody has thousands of images of infant child pornography. And let that sink in. I am limited to the 5-year maximum per image. And I have to view all of it to make sure that it fits the statute. We just can't keep up. I'm asking for a favorable result with respect to House Bill 670, and I'm welcome to any questions.
Thank you, Madam Chair. Good afternoon, and good afternoon, members of the committee. My name is Jody Kavanaugh. I'm the Legal Services Director for the Maryland Coalition Against Sexual Assault. MCASA is a statewide nonprofit that includes Maryland's 17 rape crisis centers. We represent the unified voice and combined energy of all its members working to eliminate sexual violence. Victims of child pornography suffer long-lasting repeated harm. They are sexually abused during the creation of these images, but then experience repeated harm as the pictures of their abuse are circulated. Child pornography, now referred to as images of child sexual abuse, are typically shared electronically. The material travels the web around the world and is shared by the sex offenders interested in exploiting children by viewing their sexual abuse. These cases include horrific and vile depictions of sexual abuse of children. Without providing unnecessary detail, consider cases involving children in bodily fluids or with animals or violence. And remember that the very definition of child pornography includes children who are the subject of sadomasochistic abuse. MCASA condemns pornographic images of children of any kind. HB 670 creates reasonable and appropriate recognition of the need for additional sentencing options for those who help create and sustain a market for images of younger children. For these reasons, we urge the Judiciary Committee to report favorably on House Bill 670. Thank you, and I welcome any questions.
Good afternoon, members of the committee. Thank you. My name is Zachary Payne. I'm a lifelong resident of Cecil County, Maryland, and currently employed at the Cecil County State's Attorney's Office in the Special Victims Unit along with Mr. Potashnik. I've also had the utmost pleasure of being a college professor at a university in Wilmington, Delaware, teaching on cyber law and cyber crime. The bill was drafted in part due to the necessity of catching the law up with technology. As I teach my students all the time, the exponential increases in technology make it much harder for any law to actually apply to it. Long gone are the days where we are dealing with 5 to 10 images that are secreted on a flash drive. Long gone are the days where 1 gigabyte was a massive amount of storage. That was in 1991 when it first made it to the commercial market. In 2007, we had our first terabyte. And then within 2 years, we're at 2 terabytes. Now, as of this morning, because I went online and checked, you can buy a 128 gigabyte storage for $35 at Walmart, and it is about that big. It's the size of a credit card. It can fit in your wallet. It can fit under a shoe. It can get thrown out a window. To put it in perspective, 1 terabyte is a whole approximately 6.5 million pages of documents, much more than anyone could ever produce in a lifetime. 132,000 average length novels, or frankly, the most concerning and shocking is it can hold about 22,500 minutes of video. That is 15 consecutive days of video, and we are seeing terabytes of this kind of material being traded, sold, and it's no longer you're just passing flash drives along. These are links to file sharing websites where offenders get 2 to 3 terabytes and just trade it around to the point where we can't track it. The volume that we're getting, as Mr. Potashnik said, is near unsustainable, both in terms of work hours, but also in terms of our ability to be able to do this work effectively, maintain our own emotional balance, and continue to review it, because we have to look at as much as possible. I apologize for going over, but would request a favorable report on House Bill 670. Thank you for your time.
Thank you. Thank you all. I have a couple of questions. My first question is for Mr. Potashnik, and that is what, in general, you said that there's been an increase. Who in general is can you depict for us the type of person in general that you're prosecuting, meaning a demographic, if you could give us? Or either Mr. Payne.
So, to be fair, it kind of runs the gambit, but I will tell you it's mostly middle-aged men who are involved with this type of material. I believe I've only prosecuted 1 woman for both the production and manufacture and rape of her own children, which she filmed. But for the most part, it is mainly middle-aged men who are involved with this type of material, both trading, selling, and producing.
So it's not by accident in any way. So the next question is, do you recall, I just can't remember now and I didn't have time to look it up, is there a penalty for the producer of this material?
So the production of child pornography is a 10-year felony. The distribution of child pornography also is 10 years. The possession of child pornography is 5 years.
Okay.
The problem is that the technical requirements to prove distribution is varied versus a lot of times what we're seeing is individuals who just possess on their phone thousands and thousands and thousands and thousands of images versus the individual who makes it. The person who makes it that we prosecute is kind of rare. For the most part, we're seeing a lot of this material being produced overseas as a commodity and being traded for Bitcoin, packaged in large links, and being sold here commercially or traded for other things. Traded for weapons, traded for drugs, traded for all types of stuff to feed a market. And the problem is the market wants new things. So what we're seeing in addition to just the general links that we've seen over and over again is we're seeing new children being offended on over and over again, which is disturbing because that's what the market demands.
I'm sorry I asked.
Sorry.
But we need to be informed, so thank you.
Yeah.
Delegate Concolo?
Thank you, Madam Chair. Can you explain the difference between possession and viewing? And the reason why I'm asking is because, just like the delegate said exactly, with accidental viewing, or maybe someone may inadvertently click a link, and so how do you, what's the difference
So let me explain.
there?
First, I think Delegate Cardin, I think he was the one who sponsored a bill a while ago about the viewing of child pornography and made that a crime as well, which was great. But again, you have to show that somebody saw it in a way, right? So there is a lot of myth out there about, oh my goodness, I'm clicking on the internet and oh no, I accidentally download child pornography. It's exceedingly rare to do that. In order for you to access child pornography, you have to have the knowledge and the ability and the will to seek it out. Usually you can find the stuff on the dark web. You don't just type in CSAM on Google and up pops all these links and then, oops, I just click one. You don't find the stuff on commercial pornography sites, and whatever judgment you want to give that. But a lot of commercial pornography sites, the stuff gets weeded out because they don't want to be held responsible for these types of things. So the person who collects the type of images that we're going after finds it. They look for it. Nobody accidentally finds it. It is something that you have to go after. It is a myth. A lot of times when we prosecute these things, the defense is, my client didn't know what he was looking at. He looks a lot of different types of porn. He likes this, he likes that, he likes whatever. And oh my goodness, his buddy just sent him these links, and what do you know? The law says that you have to intentionally retain. If you see it and then delete it, then you're not being able to prosecute it. There's something called unallocated space in computers, and when we look and do a forensic download, if we have all these images in the unallocated space, the person essentially deleted it, and it's very difficult, not impossible, for us to prosecute possession. We could prosecute viewing, but we'd have to show beyond a reasonable doubt that the person viewed that material, and that isn't always the easiest thing to do. Sorry, Delegate Cardin, but it isn't.
And I just have one other question, if I may. So there's another piece to this bill that allows defense if a person promptly and in good faith destroys the material or reports it. So what constitutes prompt?
Again, it's all in the eyes of the beholder, right? So, if somebody contacts law enforcement, which we've had, and so sometimes the way we see it is a parent looks at their spouse's phone and they find thousands of images. And they say, wow, this is really bad. They've seen it, they witness it, they look at it, and then they call police. Who knows how long it's been on there? But they promptly reported to the authorities, look, this is what we've got. Sometimes people don't know, and they say, is this child pornography? And then they text it to their friend, and we're not going to prosecute that for distribution because they're promptly kind of reporting it. There's no intention to retain that particular type of material. So, just like anything in the law, it is neither black or white, it's all shades of gray. It is really in the eye of the beholder. If somebody holds on to this material as blackmail, that's a bit different. But, I think we prompt usually means pretty darn quickly.
Okay. All right, thank you.
Delegate Cardin?
Thank you, Madam Chair. Thank you very much for bringing the bill. Right now, it looks like it's 10 years if you are producing, distributing, or soliciting, advertising, promoting, right? That's the language. Or possessing with the intent to distribute. Similar to drugs, I'm assuming you're going to tell us that it's difficult to prove that, and that's why you want to increase the penalties on possession. And why is there a public policy reason why possession should be equal in terms of the penalties should be equal to distribution? And I'm looking at CDS as an example as to why, from public policy perspective, possession is different than possession with intent to distribute.
So the main difference, and I've had the benefit of listening to countless interviews with police and people who possess this stuff, right? There's an addiction component to this, which is different from distribution or the intent to distribute. With drugs, you can't possibly consume a kilo of cocaine in a certain amount of time or a large amount. This is like possession plus, because remember, it's not just possession, and if you're in possession of 50 images, it doesn't really count. It's 100 images or more, or if the subject is under the age of 13, different from narcotics in that way. But people who collect this material like to retain large amounts of it so that they can look and hoard over their large collection. Like any collector, if you look at a hoarder or somebody, I collect comic books, I'm so sorry, but I do. Not the same, not the same.
Not as much.
And my collection's large. And a lot of my collection I don't want to get rid of because I like it. I like this Spider-Man issue X, or I like Batman X. Not the same, but similar to somebody who collects child pornography because they like certain images that they retain. They keep it because they're sexually attracted to it or whatnot. They don't want to distribute it. They want to keep huge, large amounts, and they keep seeking out more. People who have possession intent to distribute drugs, they don't collect drugs. I don't keep that kilo of cocaine in my bedroom because, boy, it's a shiny kilo. I keep it there because I want to sell it. I want to make money off of it. There's a distinct difference between the state of mind of somebody who collects child pornography and the state of mind of somebody who's selling a kilo of coke for money.
And they'll use that collection also to exchange for more.
Yeah.
So it's this giant, they're hoarding, all these individuals involved in this stuff, they keep hoarding more and more, exchanging amongst each other.
Not to mention, it also goes back to what Mr. Potashnik said about the market being fed by more and more demand. The more these collections grow, the more demand there is for that new material to be produced, which obviously is the most important public policy point, is to tamp out on the production as much as we can.
Thank you very much, members. That concludes this particular panel. We're going to move, we have one person testifying favorably online, Peggy Carnes. Ms. Carnes?
Yes.
Are you driving or are you a passenger?
No, I'm just sitting in a parked car.
Okay, great. You can begin your testimony for 2 minutes, please.
Thank you. Thank you, Delegate Moreno and co-sponsors and Chair Bartlett for this opportunity to speak in support of HB 670. I'm Peggy Cairns, Education Chair of the Maryland Coalition Against Pornography. I'm a retired law librarian from the Department of Justice and a mother and a grandmother. I would like to please refer you to the PDF document I submitted as written testimony to see a graphic detailing the statistical chart from the National Center for Missing and Exploited Children. I hope it will be apparent that the scale of abuse is still staggering. In 2024, the Cyber Tip Line received 20.5 million reports, including nearly 63 million files, images, videos, and other materials related to child sexual exploitation. Reports involving generative AI surged by 1,325%, climbing from 4,700 in 2023 to 67,000 in 2024, which should be a clear signal that AI-generated child sexual abuse material is growing and needs to be addressed. Regarding the added provision in this bill about the age of the victim, under 13 being a trigger for tougher penalties, please note for comparison what federal law specifies, that if the image involves a minor under 12 years of age, the punishment increases up to 20 years in prison. So it seems good to bring our state code closer in alignment with federal law. I respectfully urge a favorable report on HB 670. Thank you.
Thank you. Members, do we have any questions for Ms. Cairns? Seeing none, thank you very much for testifying with us today, Ms. Cairns.
Thank you.
I'm going to move to our unfavorable testimony. Kimberly Watts. Okay, she is welcome to come in. Hello, Ms. Watts.
Hello.
How are you?
I'm all right, thank you.
All right. Well, you're ready to provide unfavorable testimony whenever you're ready. We're ready to hear.
Thank you. I'll be brief. My name is Kimber Watts. I'm an attorney with the Office of the Public Defender. It is the Office of the Public Defender's position that we generally oppose the creation of new crimes when the already existing crimes get the job done. I was listening to and certainly empathize with Mr. Potashnik's testimony. This is absolutely devastating material. It's devastating to the victim. Our attorneys have to watch it just like he does. It is not great for us either, I can tell you that. But the bottom line remains that when you're looking at adding an additional charge, that is a different thing than an enhanced penalty. And so for that reason, the Office of the Public Defender is opposed to this bill and urges an unfavorable report.
Thank you very much. Members, do you have any questions? Seeing none, that concludes the testimony for House Bill 670. We're going to now move to Delegate Ruth, House Bill 572.
Thank you, Madam Chair. May I bring up my panel?
Yes, please.
Thank you.
Okay. Delegate, who do you have with you? We have Delta Myrna?
Yes.
Thank you. Do we have Nika Duckett Randolph? No, not yet.
Yes, she's here.
Okay, that's
here.
fine.
She's
not
here.
Okay, that's fine. She's
Thank
not
you.
on the panel. Brittany Baker?
Yes, here.
Okay. William Pirmati?
Pirmate, here.
Pirmate, that's a beautiful last name. Thomas Northrop? Nope. Okay, so next panel. Okay, great. Now, I only collect 3 people. You got to tell me who else is here.
Julie Kuspa with the Office of the Attorney General.
Okay, I have you as favorable with amendment, and I assume it's a friendly amendment?
Yes.
Okay, and who else do I have? Is that everybody? Okay.
Jennifer Misrati for the next panel.
Okay. Great.
Thank you, Madam Chair. Do you want the favorable with amendments after the others?
No, it's
Okay.
fine, as long as it's something that is easy to understand and it's not just a whole, redo of the bill. So,
Thank you, Madam Chair.
whenever you're ready, thank you.
Madam Chair, Madam Vice Chair, members of the committee, for the record, I'm Delegate Sheila Ruth, presenting House Bill 572. In 1959, the American Petroleum Institute organized a symposium called Energy and Man. Physicist Edward Teller warned the audience that carbon dioxide from burning fossil fuels would cause the Earth's temperature to rise, and that a temperature rise corresponding to a 10% increase in carbon dioxide will be sufficient to melt the ice cap and submerge New York. In 1968, a report from Stanford Research Institute, commissioned by the American Petroleum Institute, warned that significant temperature changes are almost certain to occur by the year 2000. There seems to be no doubt that the potential damage to our environment could be severe. In 1979, an internal Exxon study memo warned that under the most widely held theory, the present trend of fossil fuel consumption will cause dramatic environmental effects before the year 2050. For decades, American Petroleum Institute members were warned that their products would cause catastrophic environmental changes, and instead of changing their business model, they ran ads casting doubt on the science with headlines such as, "Who told you the Earth was warming, Chicken Little?" and "Doomsday is canceled again." Meanwhile, they were lobbying lawmakers to prevent effective policy action to halt this trajectory. Like the tobacco executives, oil industry executives knew the harm that their product would cause and chose to pursue a course of disinformation and misdirection to protect their profits. Today, we are facing the consequences of their lies. Flooding in Annapolis, Ellicott City, and Western Maryland, saltwater intrusion harming agriculture on the Eastern Shore, deaths from extreme heat, and much more. HB 572 authorizes the Attorney General to protect Maryland's taxpayers from these costs and file suit for tortuous and unlawful conduct against the large profitable corporations involved in this deception. Contrary to much of the opposition testimony, this is not about regulating greenhouse gas emissions or punishing anyone for lawful emissions. It's about holding accountable large profitable corporations for the fraud they perpetrated on the American public, a fraud which for over 65 years has prevented effective action to halt climate change. HB 572 also provides an exception to the UCADA laws for these suits, just like we granted for the Key Bridge suits 2 years ago. The Attorney General needs this exception to be able to achieve settlements. It also creates a special fund that, like the opioid restitution fund, for any proceeds of settlements or judgments. The fund is to be used for measures to prevent or repair the harms of climate change. And with that, I ask for a favorable report for HB 572. Thank you.
Whoever's next.
Thank you, Madam Chair. William Piermate. I am the Managing Director of the Environmental Law Program at the University of Maryland's Carey School of Law. I'm here testifying in my personal capacity as the views expressed may not reflect those of the law school. The legislature began this session by passing a very important bill authorizing the study of damage that climate change will cause in Maryland. It's an important step down the path towards the truth to inform Marylanders what we face in the future. The comptroller had conducted an initial study of these damages last year and measured those damages in the billions of dollars. This bill, House Bill 572, is another very important step toward the truth, empowering the Attorney General to investigate the fossil fuel industry to determine if corporations that profited trillions of dollars fueling climate change damages, whether they violated Maryland law. The bill gets at the truth. Right now, through investigative journalism, as you just heard, we know pieces of the truth. But we need the full police power of Maryland and the full power of the Attorney General's office to bring to bear on this vital issue for Maryland's future. The Massachusetts Attorney General is conducting a similar investigation. Just a couple of weeks ago, the Michigan Attorney General filed an antitrust claim against the fossil fuel industry for essentially purchasing a lot of patents for renewable energy and the like, and then retiring them and threatening lawsuits against folks who might infringe on those. That's the allegations. We'll see about the proof. Point being here, there's too much at stake. There's billions of dollars at stake, and Maryland needs to pursue every avenue of redress. Failure to do so puts the damages of climate change at the feet of taxpayers and this legislative body to figure out how we're going to come up with billions of dollars. For that, I ask for a favorable report. Thank you.
Hello, Chair Bartlett, Vice Chair Davis. I apologize for my voice today. I'm a little bit under the weather. But I'm Brittany Baker, Maryland Director of Chesapeake Climate Action Network, and I urge a favorable report on this bill. We're enthusiastic about this bill because it's a lot different than many of the other proposals that we're working on in the Environment and Transportation Committee, because this specifically does focus on the fraud, the deception, and violating consumers that live here in Maryland. Although the purpose of this bill is to apply this to climate harms, this is not something that's unfamiliar in the state. As recently as last December 2025, the Attorney General announced a $150 million settlement with Mercedes-Benz USA for a similar issue. What was happening in that case is he used the Consumer Protection Act to hold them accountable for emissions fraud that they have been perpetuating in the state. The settlement settlement resolved allegations that the company engaged in and facilitated cheating diesel emissions tests, misleading consumers, and causing dangerous and unlawful amounts of harmful air pollution. So to get back to the intent of this legislation, it is not what I'm usually talking about, which is holding entities accountable for the actual emissions. We're in here because we want you to hold them accountable for something else, fraud and deception. Thank you.
Good afternoon, Chair and members of the committee. My name is Dr. Murner, and I'm a lead scientist at the Union of Concerned Scientists. I'm here today in support of House Bill 572. This bill matters because it recognizes that the climate crisis was not solely a result of unforeseen consequences, but it was significantly worsened by decades of deceptive conduct by the fossil fuel industry. As documented in Decades of Deceit, a report I co-authored, major fossil fuel companies understood the risks of climate change from their own products as early as the 1950s, with growing certainty through the 70s and 80s. As outlined very well by the delegate, as early as 1959, these warnings were delivered directly to industry leadership. But instead of sharing that information with the public or changing course, company executives chose to protect their business interests. Internally, their scientists accurately projected rising temperatures, sea level rise, and widespread harm. Externally, those same companies funded campaigns to cast doubt on climate science, delay policy action, and tell the public that the risks were uncertain or far off. This deception includes coordinated disinformation campaigns, the use of front groups to manufacture doubt, greenwashing strategies that executives knew were misleading, and efforts to discredit or intimidate researchers. These are deliberate choices sustained over decades that help lock in today's climate damages. This bill affirms that deceptive conduct contributing to climate harms warrants accountability and gives the state the tools to respond. I respectfully urge a favorable report. Thank you for your time.
Good afternoon, members of the committee. My name is Julie Kuspa, and I serve as an Assistant Attorney General. Thank you for the opportunity to testify today. I'm here on behalf of the Office of the Attorney General regarding HB 572. We support the intent of this legislation, which seeks to authorize the Attorney General to investigate, commence, prosecute, or defend any suit or action that holds certain entities accountable for tortious or otherwise unlawful conduct that has contributed to climate change. Climate change is one of the most pressing and destructive challenges facing our planet today. This bill will empower the Attorney General to take legal action against companies whose activities continue to endanger public health and the environment. However, the Office of the Attorney General recommends an amendment. The amendment would modify the Uniform Contribution Among Joint Tortfeasors Act exemption on page 6, lines 9 through 15, to any action brought by the Attorney General arising from or relating to alleged injuries or threatened injuries to the environment or natural resources of the state. Maryland law currently presents serious impediments to the settlement of any case brought against a large number of defendants who are jointly responsible for an injury because it fails to take account for the percentage of culpability of each defendant. Currently, if the Attorney General settles a claim against one of several defendants, the state's ability to collect against the remaining non-settling defendants is reduced by an equivalent share based on the total number of defendants in the case, regardless of fault. Thus, it is very difficult to settle with smaller, less culpable defendants and multi-defendant actions without the state giving up a large percentage of its total potential recovery. The practical impact of this has been to complicate, delay, and potentially foreclose settlements in these multi-defendant environmental cases. This amendment will make Maryland law more consistent with federal law and the laws of many other states in the country by ensuring that defendants are responsible for their fair share of the harm. We have shared proposed amendment language with the bill's sponsor and are available to work with the committee on refining this language. With these amendments, the Office of the Attorney General respectfully urges this committee to give HB 572 a favorable report.
Thank you. Members, do you have any questions? Delegate Ericon.
Thank you so much, Madam Chair. Thank you for being here, Delegate Ruth. You've been here since we've passed the Next Generation Energy Act, which is prioritizing, trying to address, the energy crisis that we have, the skyrocketing prices, families paying $1,000 a month sometimes for single-family homes. How would this bill work with our new prioritization of getting more fossil fuels online?
Thank you for the question, Delegate Oregon. So as you mentioned, we passed the Next Generation Energy Act. We are trying to do everything we can to bring down consumers' energy bills. This is not about that. Would not do anything to stop the actions that under the laws that we pass that are lawful actions. This is about, and the bill says, tortuous or unlawful conduct that these companies committed and holding them accountable for that conduct. You know, the American Petroleum Institute talks about that as well in their testimony. They say that the Next Generation Energy Act is designed to increase energy generation in Maryland. And this bill is not intended to stop that. But their testimony is a little bit misleading because they also say that the legislature is being asked to vote for these bills despite previously declaring by statute that the production and development of oil and gas resources is important to the economic well-being of the state and the nation. What they don't say is that that was added to the law in 1956, which is a very different world than we're in today. And then it was most recently updated in 1993 to make it more environmentally friendly. Even that was over 30 years ago. So you have to read carefully this testimony, which is, as it's a web of misleading information and misdirection. I think you know that I support renewable energy, and as much as we can, we need to move to renewable energy. This bill is not about that. This bill is about companies who took illegal actions. If they had not taken those illegal actions, we might be in a very different position than we are today. We might be in a very different world. Thank you.
Yeah, thank you for answering that. My other question would be, this morning at peak, for example, we were less, for the whole PJM grid, less than 8% was coming from renewables. So I think the type of production that it seems like you're attempting to essentially criminalize here is actually producing 90+% of the energy that actually keeps us with the lights on today.
And thank you for the question. We are not attempting to criminalize production. We are talking about criminal acts that were already unlawful when they were committed. And of course, it will be up to the Attorney General's office to investigate those and to determine about the lawsuits. But we are not trying to criminalize production at all.
Okay, and Madam Chair, my final question would be, isn't this what the Clean Air Act already does? Wouldn't this be very redundant?
I'm glad you asked that question. First of all, even if that were relevant here, which it's not, because as we've said, this is not about regulating emissions. This is about criminal acts already committed. But even if that were relevant, just a few days ago, the EPA revoked the endangerment finding. That endangerment finding was what allowed the EPA to regulate greenhouse gas emissions under the Clean Air Act. So this current administration in Washington, D.C. has now said the Clean Air Act does not cover greenhouse gas emissions. It does not allow us to regulate greenhouse gas emissions. I would also add, in terms of your previous question, as far back as 1967, the American Petroleum Institute was telling Congress, you don't need to develop electric cars, because by the time electric cars are developed, then our fossil fuel driven cars will be so effective they won't be emitting anything. So if those oil companies had not been lobbying Congress, we might have 80% or 90% of the, please.
If I could add, the Clean Air Act only governs the emissions of pollution into the atmosphere, right? It does not cover whatsoever deceptive trade practices. There is nothing in the Clean Air Act that deals with that kind of violation of the law.
Okay, so then her example of the oil company coming in and saying, like, cars are going to be so essentially clean with fossil fuels, is that a crime?
So misrepresenting your products to consumers not telling them the risks of those products is against the law.
Okay, so then this bill would allow us to go back in time and sue these people for saying that cars are going to be clean 30 years later?
Only if the Attorney General finds that they violated the law in selling a lawful product. So think in terms of the tobacco industry.
Okay.
Right? They weren't put in trouble because they sold cigarettes. They were prosecuted and sued because they sold cigarettes and they purposely misinformed consumers about those risks.
Okay, so
that's what we're getting at. And that's how the Attorney General got involved in the tobacco settlement back in the 1990s. And this is very similar.
So the theory would be that the car manufacturers were selling cars in the 70s, claiming that in 30 years they would be green?
I'm pretty sure the bill says the fossil fuel industry and not
the whole industry?
I believe that's the language in the bill. It's
Okay,
the fossil fuel
not
industry.
the downstream.
Absolutely not. Thank you.
So not the car manufacturers that were referenced.
It specifically references people who are or were extracting, refining, or producing oil, coal, or gas. So not car manufacturers.
Okay, but were those the ones that were testifying? Who was testifying that cars were going to be green in 30 years?
American Petroleum Institute. And it wasn't testifying that cars were going to be green. They were testifying that the cars driven by oil and gas were going to be clean, and so we didn't need to do anything else.
Gotcha. Okay, thank you.
Thank you. Delegate Embry.
Thank you, Madam Chair, and thank you, Delegate, for bringing this bill. I just want to give you a chance. You've responded to some of the arguments made by the opponents, but another one is the Chamber of Commerce has argued that it's premature because we are, as was pointed out, going to do a study, the Renew Act, and also we have the litigation in Baltimore. So I just wanted you to be able to respond to why this is relevant to do now.
Thank you for the question. So there's two parts to that. First of all is the Renew Act study, which quantifies the costs that these emissions are costing our taxpayers. Nothing prevents the Attorney General from filing suits now. We won't need to know what those costs are until they get to a point of settlement or until there are judgments against them. And so we want to make sure that the Attorney General has the tools. Now, maybe the Attorney General will investigate and decide there is no suit to be filed, but that's up to them. We want to make sure that they have the tools. As far as the Supreme Court case, it's the same thing. If we wait for a decision from the Supreme Court, we might be out of session, and then the Attorney General would be stuck because we can't authorize this once we're out of session, and we can't make the UCATA exception that they need once we're out of session. So it's prudent to put this tool in place so the Attorney General has what they need to begin the investigation and, if necessary, to file those suits before we're back in session next year.
Thank you very much. Thank you.
Delegate Cardin.
Thank you, Madam Chair. Thank you very much for bringing this bill. Bill, it's great to see you.
Great to see you,
best class of the 2000s was 2001, right? Not 2000. Okay. So in order, I'm stepping back for a second to make sure I understand. In order for the Attorney General to be able to do this, they do not have the authority to prosecute crimes in the absence of specific statutory authority or an executive order. And that's why we're having this legislation. Is that correct?
That's my understanding,
okay.
Yes.
So going back to the question from Delegate Erican, and the comment about the greenhouse, about the Clean Air Act. Isn't it true that the Attorney General specifically authorized in 16-106.1 of the state government article to investigate, commence, and prosecute or defend any civil or criminal suit or action that is based on a federal government's action or inaction that threatens public interest or the welfare of the residents of the state. So it would seem to me, and justify this if you can, that the Attorney General may already have the authority once the federal government decided not to enforce the Clean Air Act.
Well, two things. Number one, I think the really important word you use there is may have the authority. Now, I don't think I have to tell you, Delegate Cardin, that the fossil fuel industry is well represented. They will use any loophole they can to avoid accountability. And I think it's imperative to lay out crystal clear the authority of the Attorney General to investigate and uncover the truth. That's really what this bill is about. Let's get to the truth. What did the fossil fuel industry know? What were they communicating to us consumers? Were they acting in concert? All of those things are vital to know. The second part is, again, the Clean Air Act gives the federal government no authority whatsoever to go after some sort of deceptive trade practice. So the federal government inaction here can't be seen as a trigger for Attorney General authority.
Perfect. Okay, great. Thank you.
Do you want to?
Exactly what I was hoping.
If I could add, I think the statute that you just read, the Defense of Maryland Act, is actually authorizing the Attorney General to sue the federal government. The bill that we're putting forth now would allow the Attorney General to sue these companies. So, according to the Maryland Constitution, for the Attorney General to sue, he has to either have statutory power or the power, a letter from the governor. So this would be essentially giving him the ability to bring these actions. And I just want to reiterate, this isn't giving the Attorney General a new cause of action. It's not creating liability that isn't there. It's just allowing him to use the tools he already has to bring this action forward.
Thank you.
Madam Chair, may I add one thing?
Briefly.
Thank you. I just also wanted to add that the Attorney General needs the change to the UCADA, and that's something that I believe only we can do.
Thank you for that. Delegate Moreno.
Thank you, Madam Chair. The Maryland Retailers Alliance written testimony argues that this is so broad that it could expose Maryland businesses to liability for simply conducting basic operations. Can anyone on the panel, explain clearly whether and how this bill could ever reach Maryland businesses engaged in lawful routine operations?
Thank you for the question, Delegate. The answer is it can't. I'm very sad to see that the Maryland Retailers Association has picked up some of the talking points from the American Petroleum Institute, because the Maryland's retailers are impacted by climate change. For example, flooding. Many of the retailers in downtown Annapolis are experiencing regular flooding, and we would want those settlements to be able to help not only the state, but hopefully local governments and businesses as well. And as long as they did not commit tortuous or unlawful actions, they should be fine.
Could I add, please, to that? So,
thank you.
Secondly, I believe the act only applies to one, publicly traded companies, and two, they have to have a market cap above, I believe, $1 billion.
Okay.
So there's safeguards put in place that the mom and pop retailer, even if they're selling gasoline, which is perfectly legal and doesn't expose anyone to liability, is fine. This bill won't touch them. They must commit some other crime engaged in the fossil fuel industry and be defined within the parameters of the act, including being publicly traded and a large entity. In other words, large enough where they should know better.
Okay, thank you.
Thank you. Seeing no further questions, that concludes the testimony with this particular panel. We're going to move to Ms. Randolph, Mr. Thomas Northrup, and your name, ma'am?
Jennifer Mizrahi.
Ms. Mizrahi, are you representing another organization?
Mizrahi Family Charitable Fund. Also, I'm a Maryland Climate Commissioner, and I serve on Brooke Learmon's Climate Task Force. But I am.
Are you favorable?
I am favorable.
No, I don't see. I don't see you on the list. Hold on 1 second, please. In fact, Ms. Randolph, you can go ahead and start.
Good afternoon, Madam Chair Bartlett and members of the committee. My name is Nika Duckett-Randolph, and I am the resident environmentalist at Out for Justice, a member-based grassroots organization dedicated to engaging, educating, and empowering communities to build power to dismantle harmful systems of oppression. I want to speak today about equity. Specifically, who bears the burdens of climate pollution in Maryland and who benefits from polluters avoiding accountability? Right now, the costs of pollution fall hardest on communities that are already overburdened and underserved. In Baltimore's infamous black butterfly, decades of intentional environmental degradation and disinvestment have left black neighborhoods exposed to multiple intersecting health risks, from asthma and heat stress to legacy-led exposure, blight, and flooding. Even as childhood lead poisoning has declined due to strong prevention laws, lead hazards remain a serious concern in older housing stock, with no amount of lead being safe for children and contributing to lifelong health and public safety concerns. Baltimore experiences some of the worst asthma hospitalization rates in the nation, with elevated rates tied to air pollution and climate-linked factors like heat and precipitation that exacerbate respiratory conditions. Extreme weather events are no longer rare. Flooding and nuisance tide events are increasing, threatening public safety, damaging infrastructure, and imposing costs on families and local governments that had no role in causing climate change. These harms to health, safety, housing, and economic stability are not evenly distributed. They disproportionately affect Black Marylanders, low-income residents, children, and older adults who lack the resources to recover on their own. That is fundamentally inequitable. Maryland's experience demonstrates that climate delay was never neutral, and these polluters' actions have grave consequences they never intended to face. Instead, they redistributed the harm onto the most vulnerable communities and future generations. Understanding this history is critical to ensuring that current climate and environmental justice policies are not undermined by the same tactics of delay and doubt. Please, I urge a favorable report on Senate Bill 572.
Thank you, Chair and members. My name is Thomas Northrup. I'm a Master of Social Work student at UMB, testifying in support of the bill on behalf of social work advocates for social change. Marylanders are ready for climate accountability. Across the state, there is broad support for finding deceptive fossil fuel providers, and that support is growing as extreme climate events intensify and more of us are affected by them, which we are. Every county in the state has had at least 2 climate disasters in the last 15 years, and every time Marylanders have footed the bill. Let's take the recent ice and extreme cold event during which Marylanders paid out the wazoo to keep our homes warm. Pipes burst, street cleanup took weeks and it's ongoing, and the icy roads have led to fender benders, but unlike with the damaged car, where we all agree the responsible parties pay for it, the parties responsible for climate disasters never pay, leaving us to foot the bill. But Marylanders know that fossil fuel providers are liable, that those companies' lies helped pad their pockets. So just like we know that the driver who rear-ended us needs to pay, we also know that fossil fuel providers need to pay. This summer, fossil fuel-induced climate change caused the deadliest heat waves on record in the state. I was doing heat safety workshops in Baltimore City, and in 2/3 of the senior apartment buildings where I worked, the AC was broken. 100 degrees for days on end, and no AC for the vulnerable residents. They were terrified that there wasn't enough money to replace the HVACs. But across Maryland, we all felt the heat and paid more for AC than ever before just to stay safe. We paid, not fossil fuel providers, even though their lies and pollution caused the extreme heat. That's why in interview after interview, poll after poll, a majority of Marylanders say they want action, in particular, fines on fossil fuel companies. For all these reasons, we urge a favorable report on HB 572. Thank you for your time.
Thank you, Ms. Roddy.
Madam Speaker, Madam Chair and committee, I'm delighted to be here. My name's Jennifer Laszlo Mizrahi. I serve as a Maryland Climate Commissioner, also on Brooke Lehrman's Climate Task Force, and I'm a climate philanthropist, and I am testifying on my own behalf. I grew up in the #1 tobacco farming place in the country in North Carolina. My dad is a cancer doctor. It used to be that the tobacco companies gave free cigarettes to all of their employees for free, and they told them that it was good for you. Time after time, my father treated these patients, and they were dying while their employer was telling them that these were healthy products. We have exactly the same situation here with big oil and with big gas. When my father was a doctor, he could treat patients one at a time. But you as legislators, you're in a very important position because you can set up the law to enable the Attorney General to hold these companies, these multi-billion-dollar, multinational corporations, which, by the way, zero of which are Maryland companies, accountable for the deception and lies that is costing us billions and billions of dollars. I also just want to say personally how much I appreciate your service. I woke up this morning here in Anne Arundel County to learn that somebody who was canvassing for a candidate was threatened with his life, with racism, and with all kinds of hate because they were simply being part of democracy. I recognize that coming into this building, you have to go through security, and now when you leave this building, you need security because your jobs are in jeopardy, because you guys are so important. The work that you do is so valuable. I appreciate you all so much. The power that you have over fossil fuel companies that deliberately lied to us is enormous. I urge you to support this bill, and thank you for your service to democracy.
Thank you. That's very nice. Delegate, is that Arakon's light? Okay, Delegate Arakon. Thank you.
Thank you, Madam Chair. Thank you guys for being here today. So I'm just curious, I mean, I hear a lot of negativity. And look, folks in this committee know I'm very plaintiff-friendly for a conservative. So I'm not afraid to sue people for being horrible. I think it's the great equalizer, actually, of society. I'd rather litigate than regulate. But there's a lot of demonization right now about fossil fuels, and as I said to the previous panel, that is why we have lights on right now. Like, we are not, this much of our energy is coming from renewables that are not contributing, they're not fossil fuels. So what kind of impact do you think this policy could have on producers and then ultimately ratepayers if the companies that are producing, these products are being publicly shamed, penalized, demonized, even more than they already are they going to, we've lost a lot of producers in our state. It's why we had a blackout a few weeks ago. We didn't have enough load to keep all the homes online. What will happen if we continue to demonize these products that are actually keeping people alive?
Delegate, I appreciate the question. If, when they knew about their harms, it became public and they did not deliberately disenfranchise us from making smart decisions, there would be a lot more energy like what we have from Calvert Cliffs. The nuclear energy that we have in our state is now providing 40% of the in-state power that is created here. It probably would be a lot more. The wind farms or the solar, we would probably be much further along. Perhaps investments in fusion or hydrogen or other things would have been further along. But that's not what this bill is about. This bill is not about keeping people from using fossil fuel or advancing it. It is simply to hold people accountable for consumer fraud and for deliberately lying. So it doesn't do anything in this legislation to reduce energy supply whatsoever. It holds people accountable for illegal acts that they did in the past that were illegal at the time that they did them.
I appreciate that.
I can add to that to address the part of the question about consumers.
Let me get back to what she said,
okay.
and
sure.
I do appreciate that, but I think what we've seen is, the legislature keeps saying, oh, we haven't closed any of these power plants down, which is technically, they never passed a bill to close power plants down. But the climate here around fossil fuels has become so toxic and so regulatory burdensome that businesses have closed down and now they are refusing to come here. So it does, even if we are not specifically passing a bill that says we're going to close you down, passing these kind of policies has led to companies leaving, companies refusing to come, and now our citizens paying astronomical prices for their energy because we're importing it from outside of our state, much of it not green. We're pulling, it says right here, gas today, 42%, nuclear 28%, coal 16%. I mean, that's what we're actually using, and we're just pulling it from other places now. So I hear you, and I hear what you're saying, and I do like punishing bad actors. I think it's the appropriate thing to do in most cases. But also, is it worth it to punish bad actors if what we're actually doing is turning the lights off?
To my knowledge, that's not what's happening, because this bill focuses on fossil fuel producers that are publicly traded and worth more than $1 billion. So the price of energy, which is higher than it's ever been, is not in fact related to fossil fuels, the price of fossil fuels increasing. Moreover, the price will not go up if these companies are fined, because in order to be competitive in the marketplace, they will have to sell their products on par with companies that are not publicly traded or are not worth more than $1 billion or are not doing business here.
Let me expand on what.
My concern, though, is that they decide to leave. They leave our market. That is my concern. I appreciate you guys, but my real concern is that, like all these other businesses, they choose to walk away from Maryland, and that's their decision. But I do appreciate you guys going back and forth.
Okay, thank you. Members, do we have any other questions? Seeing none, that concludes this panel's testimony. We have one unfavorable. Hannah Allen, are you here? Okay. All right, Ms. Allen, whenever you're ready, you can begin your testimony for 2 minutes, please.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. For the record, Hannah Allen here today on behalf of the Maryland Chamber of Commerce in respectful opposition to the bill. You have a copy of our written testimony, so I won't do a deep dive. I think the first thing I'll note is that the bill in our read isn't just addressing the company's own emissions in Maryland, but instead would authorize claims based on the downstream use of products sold into a global marketplace. Once those products are lawfully sold, their use is governed by federal and international frameworks, not just Maryland law. So holding a narrow set of companies responsible for the independent actions of countless third parties is raising significant concerns and economic uncertainty. Second, I know this was discussed, climate change is inherently interstate and international. Courts, including Maryland courts, have repeatedly found that these types of claims are preempted by federal law. Maryland courts have applied that same principle in dismissing climate lawsuits that were brought forward by Baltimore City, Anne Arundel County, and Annapolis City, which are currently now on appeal. I'll mention the federal pullback of the endangerment finding doesn't give states new authority to regulate interstate or global emissions through tort law. And then I just want to jump back to the Next Generation Energy Act that was discussed. There is certainly concern just over the message that this sends, right? This is exposing energy producers to sweeping retroactive liability. We're concerned over the signals that sends to the marketplace and to investors, and undermining reliability and affordability at a really critical time in our energy landscape. And then lastly, I just want to touch on the Renew Act, which I know the advocates discussed. The Renew Act was a very similar bill introduced last year. It was amended to become a study. That was the debate and discussion that the legislature had last session. So we are awaiting the results of that study that are due December 1st. So we'd really love to see what that says before moving forward with this legislation at the very least. So I'll stop there. Thank you.
Thank you for your testimony. Delegate McComas.
Thank you, Madam Chair. I just glanced at the letter from the Chamber of Commerce, and I'm like, we could be in litigation for the next millennium almost. I guess what I'm concerned about, are there any other states that you are aware of that have done anything, maybe 5% of what this bill wants to do?
Yeah, I think the litigation and the costs that the state could incur because of it are concerning. I know Vermont and New York have ongoing federal lawsuits. arguing that it's unconstitutional and preempted by federal law. There are, of course, the ongoing suits in Maryland that I discussed as well. So I think courts we've seen in federal, common law have dismissed the cases at that level because of concerns over federal preemption. So I think the concern to the cost of the state is real. And that's something that we're thinking about as well. We have aggressive climate goals. There was a study a couple years ago that said we need over $1 billion to pay for those goals. There are many efforts to try to raise money to pay for climate mitigation and to meet those energy goals. But I think the concern here is that would also tie up states' resources, limited resources.
So would it be better to work on cleaner energy? Okay, to do research and R&D for that, as opposed to getting involved in lawsuits that they may be endless. I mean, I just think that this is like a waste of money to get involved in this.
Yeah, I mean, I think you make a good point. Yeah, yep, I would agree.
Thank you. All right, members, that concludes our testimony for House Bill 572. We're going to move on to House Bill 692, Delegate Tolles. Delegate Tolles, welcome back to Judiciary. And
yes. Oh, you can't. I would tell you I was suffering over there. I was like, if they ask any more questions, good to be back.
We've got plenty of questions for you, Delegate Tolles. Whenever you're ready, you may begin.
Thank you, Madam Chair. Hello, Chair Bartlett and Vice Chair Davis. I will not be before you long because you passed this bill out of Judiciary last year, and essentially, hey, amen, let's go, move favorable. Do I still get a vote? With Carterway, he's always still on my side. But, this bill we talked about before, porch piracy, and, it's the number one concern that many of our residents have. The former chair, he's not here anymore, but recently over the summer, and those in Baltimore City know that there was, a major porch piracy situation that happened in Baltimore City. And I'm not picking on Baltimore City because it happens in Prince George's, it happens all throughout the state of Maryland. And it's a real problem that we have with individuals. To me, it's a quality of life crime. It's the issue of, hey, I'm just going to take stuff off the porch, and oftentimes it's medicine that our senior citizens need, particularly with what's happening with our healthcare system in the country. Getting medication shipped to you is a lot more affordable. And so when folks taking packages, they don't know what they're taking. They just say, I'm going to take something because I see it. Multiple states have passed this bill before, from New York to Michigan to New Jersey. And we just need to, make sure that we hold individuals accountable. I know my friends in the Office of Public Defender don't like anything that's increasing penalties by $5 more or jail time by 2 days. But, this committee last year, with the hard work of Delegate Moon's subcommittee and others, really worked to massage the bill. So it's a misdemeanor essentially, and it's just saying that if you commit multiple crimes, then you will be penalized. And I just want to say that in reference to individuals with convictions not being able to get employment and housing and food benefits, again, when you talk about quality of life crime, this is not a matter of whether you are, taking something so you can eat. This is not the organized retail theft bill that you pass and folks are wondering if they could, afford to get food, their, food insecurities and so forth. And even that situation was a strong organized retail crime. You're talking about taking packages off individual porches that oftentimes people need for their quality of life. So with that, I will stop there and I ask for a favorable report on the bill we passed last year. Thank you.
Thank you very much. Delegate Tolles. Delegate Valentine, you have a question?
Thank you, Madam Chair, and thank you, Delegate, and good to see you. I just wanted to confirm, this is in the exact same posture as what we passed last year unanimously?
So the only thing that we took off, because I understand that the Senate had some issue with it, was Delegate Conaway's favorite facial recognition. So I'm sorry, sir. Don't look at me like that. But we just took that off. If you are more than welcome to add that back. I know that was a bit of a contention with the Senate side, which is why it did not pass out of the Senate. But of course, we do everything right in the House. So feel free to add that back. Other than that, it's in the same exact posture.
Thank you.
You're welcome. Yes?
Thank you. And since his name has been invoked,
no, I'm in trouble.
Delegate Conaway.
Thank you, Chair. Thank you, Delegate, for bringing this bill. So in reference to the facial recognition, can you speak to that part that you took out?
I can't, because I think I cannot do it any justice like you would.
Okay, well, as a separate bill, I think I have a facial recognition part. So we took that out. And when I presented my bills earlier, I did state that you were very instrumental in helping me formulate the way I did the bills and being able to extract the essence out for the various purposes.
Yes.
So I want you to know that the facial recognition is coming.
Thank you so much. No problem. I thank you for, our partnership over the past couple years of trying to get a bill like this out of committee and to become law. So, we in this thing together. So whatever you all need to do, it becomes a work product of the committee that I no longer have say on. So I just want us to improve our quality of life as best we can in a fair and most just way that Madam Vice Chair would be in agreement to.
Well, one more part. Do you find that the taking of
she knew I know her and I had some discussion, so I'm picking on my colleague next door in Charles County.
Do you find that the stealing of medical packages are increasing, and are they showing up being sold online, that type of thing?
That's a very good question. When you have, prescription, particularly addictive prescriptions, I do not know what they are, but those addictive medications that oftentimes the pharmacist or your doctor will allow you to get a certain portion over a certain period of time definitely can be stolen and be sold publicly. I'm sorry, not publicly, can be sold kind of, in the black market or whatever they call it, in the streets. So, that's even more reason to make sure that we look to pass a porch privacy bill that will really increase the penalties a bit to, ensure that you don't have that happening in our community. So thank you for that question.
Thank you, Delegate.
And I'm sorry, Madam Vice Chair.
Well, you made Delegate Conaway smile, so
I did.
We're good.
I always like to do that.
There you go. Members, do we have any further questions? Okay, Delegate Woods.
Just a quick follow-up. Thank
Sure.
you, Madam Chair. Regarding the prescription medications, I thought when there was medications like that, they had to be signed for. Are you saying they're prescription meds that can be left on your porch? Okay, I'm hearing a whole lot of stuff, but I have no idea what being said.
The committee said no, so I'm agree with what they said.
Well, Delegate Woods comes from the former Health and Government Operations Committee, so.
That's a bill next year that's
Yeah,
signed.
okay. Any other questions, Delegate Woods?
No.
She just shot.
All right. Members, thank you. And Delegate Tolles, thank you. And you're always welcome in the committee. That concludes the bill hearing for House Bill 692. Our final bill for the day, House Bill 759. Delegate Stinnett.
Of course.
I miss you on this side.
I am missed. I know it's no fun anymore. You're on Glee.
I'm gonna call a few names here.
It's fun. Go back.
Do you have a panel, delegate?
Yes.
Okay. I'll let you call them up and then I'll start calling names.
Right. I know a few people had dropped off.
Okay, I've got Nicola Nabel Juris,
Yeah.
Brian Sagenti, Eddie Ellis, I see you, Crystal Carpenter.
She's not here.
Okay, and I don't see Magdalena Saunders. Yes, I do. There you are. Do you want to come up now, or? She's the last. We can fit 6, so.
Yeah.
If we can, let's do it. Anthony Wazir Muhammad.
Oh, no,
Okay.
he's not here.
All righty. Well, if Delegate, when you're ready, if you would begin, please.
Okay. Good afternoon, Chair, Vice Chair, members of my Judiciary Committee. It's a privilege to be here this afternoon to introduce Bill 759. This bill addresses a much-needed technical correction to the Juvenile Restoration Act. The Juvenile Restoration Act was grounded in principles I hold deeply, that children are capable of growth, that mistakes should not define a lifetime, and that no young person is beyond redemption. As a Black man, I understand how quickly our children can be labeled and how rarely they are afforded grace. As a parent and a coach, I have seen firsthand the transformation that happens when young people are given guidance, structure, and real opportunity to mature. As a man of faith, I believe we are called to extend special care and protection to the youngest and most vulnerable members of our community. The recent important reforms of the Juvenile Restoration Act and Second Look Act recognize that young people can change and create opportunities for second chances. For children under 18 in Maryland, however, eligibility for these opportunities is based on an arbitrary date, not the date upon which their offense occurred, but on the date upon which they were sentenced. That technical distinction does not operate the same way for individuals who are 18 to 24, creating an inconsistency that is disconnected from the principle that youth itself is what matters. As a result, for young people who encounter the justice system today, we have created 2 communities of young people in Maryland with vastly different rights. Individuals who are under 18 who have no mechanism for sentencing review, and young adults who are 18 to 24, most of whom will receive review. Our laws, both in Maryland and nationally, typically provide children with more rights and protections than individuals over 18, not fewer. However, this is exactly what is happening right now. Children are receiving fewer rights and will receive harsher sentences as a result. We already know that Black children and children of color experience discrimination at every stage of the criminal legal system, from arrest to charging to sentencing. Black youth specifically are more likely to be charged and convicted in the adult justice system, more likely to receive harsh sentences, and more likely to serve lengthy terms of incarceration. While all children sentenced after October 1st, 2021 lack the opportunity for sentencing review, we know that this unfairness in the law would disproportionately impact Black youth, their families, and their communities. While I was not in the legislature when the Juvenile Restoration Act was passed, I have seen firsthand the power of this policy. Many members of my community went to prison as youth and now have returned home via the Juvenile Restoration Act. Individuals sentenced to lengthy sentences as youth are now powerful mentors and serve as violent interrupters and reentry specialists, both in my Baltimore community and across the state. And I hope for a favorable report.
Thank you. Whoever is ready to go next can go, please.
Good afternoon, Chair Bartlett, Vice Chair Davis, and members of the committee. My name is Nicola Nabel-Juris, and I'm the National Legal and Policy Director at the Campaign for the Fair Sentencing of Youth. We're grateful to Delegate Stinnett and Senator West for sponsoring this bill. CFSY is a national organization that collaborates with policymakers, national community organizations, and individuals who have been impacted by these policies to develop solutions that keep communities safe while giving children the opportunity to reintegrate to the community after they've been rehabilitated. CFSY was intimately involved in the 2021 passage of the Juvenile Restoration Act, which had a groundswell of support from community members, state's attorneys, former judges, survivors of youth violence, the Maryland Office of Attorney General, and national organizations such as the Responsible Business Initiative for Justice and the Players Coalition. The JRA addressed racial and legal inequalities related to the extreme sentencing of children, including creating a judicial review mechanism for children who are under 18 sentenced before the act. Over the last 20 years, the U.S. Supreme Court has repeatedly reiterated that children are different for the purpose of criminal sentencing. But it's unheard of for a state to respond to these court decisions by giving children under 18 fewer rights and protections than their adult counterparts. House Bill 759 is a simple technical fix to ensure constitutional compliance and fundamental fairness for youth in the criminal justice system. We note that it's supported by the Maryland Office of the Attorney General, business leaders like SEIU Local 500 and the Responsible Business Initiative for Justice, faith communities including the Maryland Catholic Conference and the Maryland-Delaware Synod of the Evangelical Lutheran Church, and national organizations such as Fair and Just Prosecution and the R Street Initiative. We urge the committee to not ignore these inequalities now that they've been identified. It's imperative that we correct this problem now and not wait, because it matters to children now who are facing these lengthy sentences. They deserve to have the same rights and protections that their adult counterparts do in the system. We encourage that the committee favorably report House Bill 759. Thank you so much for your serious consideration.
Thank you. Whoever's next, you just need to move your microphone over. Thank you.
Good afternoon, Madam Chair, members of the committee. My name is Brian Ciceni, here on behalf of the Maryland Office of the Public Defender. We're requesting a favorable report on House Bill 759. This bill is a technical fix to Criminal Procedure Article Section 8-110, which allows certain individuals who have served at least 20 years for an offense that occurred when they were under the age of 25 to file a motion for sentence reduction. A normal benefit of legislation like this is that it gives people hope and an incentive to improve themselves and to rehabilitate. This benefits everyone, the individual, society, and the correctional officers and staff and other incarcerated individuals who interact with these individuals. Currently, Criminal Procedure Article Section 8-110 does this for most young adults who receive lengthy sentences, but paradoxically, not for minors. If our young adult client today receives a lengthy sentence, we can tell them, don't give up. Do your best while incarcerated, stay out of trouble, do every program that you can, and a judge will consider that in the future. But minors sentenced today do not have that opportunity. The sentencing date limitation deprives minors of that incentive, of that hope, and it nonsensically treats children worse than young adults. The sentence date restriction, I would suggest, was never good policy. The way in which judges sentenced minors convicted as adults did not suddenly change on October 1st, 2021. We didn't hand out a crystal ball to every judge that day that would allow them to predict whether decades later a young person might change such that a less severe sentence would be appropriate. That's what this law is supposed to do. So for all those reasons, we respectfully request a favorable report. Thank you.
Thank you. Hello, Chair and Vice Chair, and members of the committee. Thank you for this opportunity today. Before I move on, I would like to thank Delegate Stinnett for introducing this legislation. My name is Eddie Ellis, and I serve as the co-director of outreach at the Campaign for the Fair Sentence of Youth. When I was 16 years old, I was arrested and charged in a homicide case. I take full responsibility for what sent me to prison, and I take full responsibility for who I am today. I spent the next 15 years in prison doing everything I could to better myself despite the limitations of the system. This year will mark my 20th year since I've been released, and I have dedicated my life to support young people and strengthen our communities. I also have the wonderful opportunity to work with former life sentence children across the country called the ICANN community, but I also work with the National Family Network, who is comprised of family members of those who are serving time and also those who were harmed by youth violence. I'm here today in support of House Bill 759, the technical fix to the Juvenile Restoration Act. I firmly believe that anyone who is eligible to apply under JRA should have the opportunity to just resentence or have their case reheard. For me, people said that I would never change, but I have. 20 years since I've been home. I'm a husband, I'm a father. I take pride in supporting folks who are coming home, and I, support one of the JRA folks who come home under the Maryland group that we've been running for the last 5 years. And we're doing everything we can to support the men and women who have come home. But I truly believe that there's many others who deserve this opportunity as well, and most likely do way better than what I'm doing with my life right now. But please allow a favorable amendment for this bill. Thank you.
Thank you.
Thank you, Chair Bartlett, Vice Chair Davis, and members of the Judiciary Committee. My name is Magdalena Chungus. I'm the founder of the Maryland Second Look Coalition, which I started on behalf of my partner, who's been serving a life without parole sentence since 19 here in Maryland. As a coalition, we drafted the original language of the Second Look Act, which many of you co-sponsored, which would have included an opportunity for sentence review for those under 18 convicted after 2021. The current language is a technical error caused by amending the Second Look Act and adding it to the JRA. But barring these children from this opportunity going forward is illogical and needlessly cruel. Last week, our coalition provided court support at one of the first Second Look hearings held since the law went into effect in the fall. Your leadership has made that opportunity for individuals to demonstrate their rehabilitation. There, a mother who was doing court support told me that her incarcerated son, who was a teenager, would have the opportunity for a second look if this bill passes 20 years from now to show his rehabilitation. The people who have rehabilitated and re-entered the community after being granted relief from the JRA have shown that there is so much value to be added to our communities with them being home. I know this because many of them are leading the work in this coalition. You may have met a few of these individuals today who came home off of the JRA if you were at the University of Baltimore Annapolis Day, who continued their education at UB since coming home. And I ask that you show a commitment to fairness and justice and a belief in second chances. And I urge a favorable report on House Bill 759. Thank you.
Thank you. Members, are there any questions? Delegate Taylor.
Thank you, Madam Chair. I guess to the sponsor or whomever can answer this question. Thank you, first of all, for bringing this bill, which plugs the gap that we knew was going to exist once we passed the Second Look Act. How many individuals, incarcerated individuals, might be covered if this bill passes?
I can attempt to answer that, Delegate Taylor. So essentially what this would do is that starting, I guess, in around 2041, when people who are sentenced on or after October 1st sort of age in, reach the 20-year mark of that they've been in for 20 years, they could then, like people sentenced before then, file a motion for sentence reduction. We are seeing new people kind of age in now and reach 20 years at, if I had to ballpark it, a rate of maybe 30 or 40 a year. That's a ballpark. I don't know exactly what it'll be in 20 years, but I suspect it'll be something like that. It won't be some giant number.
30 or 40 year, 20 years, approximately.
Well, 20 years from now, that's when I think you'll start seeing 20 years from 2021. That's when you start to see the impact of the bill.
Okay, thank you.
Thank you. Delegate Conaway.
Chair, thank you, delegate and panel, for coming in to testify. So the people who are being convicted, they're being convicted for what kind of crimes? Can anybody help me out on this?
The JRA, the Juvenile Restoration Act, applies to anyone who is under 18 at the time of their offense. So any offense would make an individual eligible for this review as long as they've served 20 years.
Yeah, what kind of what kind of offense would you have committed? What kind of offense would you have committed to be sentenced for 20 years?
There's a combination of ways that people get lengthy sentences. Sometimes I understand you're reaching for it up to including individuals who have committed homicide offenses, but there's also ways that people have stacked sentences such that if you commit more than one robbery and a judge crafts a sentence, it is possible to get a lengthy sentence for lesser offenses.
Concurrent sentencing?
Consecutive sentences.
Consecutive sentences. Okay, that's what I was trying to get to. Thank you.
Members, any further questions? Delegate McComas?
Thank you, Madam Chair. This is a little offline, but I think Mr. Eddie Ellis, you probably could tell us what we need to do since you've been through the system. I mean, are there things that you think really that are still present being done in the system that we need to kind of think about?
Well, I think for me, more opportunity for programming to allow people to program. The folks who've come out and have proven themselves to do right, allow them to go back in the system and be a part of people transitioning and getting their life together. More family reunification, more opportunity possibly for transformative healing, circle processes with families and also survivors if the opportunity is there. But I just say, it's a lot of folks who've come home who have really taken this opportunity very personal because of what they've done. And we know that we can't change what we've done, but it's very important to us that we be safe as well and our families be safe. And that's why we immerse ourselves in the work that we're a part of to help be a part of that change. And being able to go back to create hope in other people not only makes the system safer, it makes the correctional officers safer, the folks that's being housed there safer, because they're seeing true opportunity there in front of them with the people who've come home. So I just would say allow more programmatic opportunities, more family reunification, and allow people to go back in and be a part of the process to support folks.
Do you think it's also important that maybe we provide the juveniles that are in the system and when they get older, that when they come out, they have one or two different trades? As or in other words, something that they, whether it be carpentry, plumbing, electricians, and I think things are just going to change, but still, we do need plumbers. So I just was wondering if you thought that, because I know I had spoken with someone who worked in a prison, not worked, but were, they were very involved in like a prison ministry, but they said the most important thing was if you had a job coming out that you liked and you were happy and that you could move on.
It matters a lot, and it helps with not only our own family, with the local economy. It helps people stay out of trouble. So yes, those opportunities are very important. As we see, a lot of those trades have went away. So if we could bring those trades back and allow people to be a part of those trades and come home and be certified in it, and not just do the job and not being able to be certified to come home and do the work. Certify them in the work and let them come home. It creates wonderful opportunity. Generational wealth, I think, because it's a real career.
I do want to add that there's a number of organizations that, that has the ideas of what you're speaking of. I know one particular trade is CDL training that's really popping up with a lot of organizations that are working with a lot of people that are coming out looking for opportunities and so forth, even HVAC and so forth. I think, different companies like North American Trades are really reaching out to several communities, because particularly in my district, there's a new branch that are reaching out to the community and finding opportunities, and especially even dealing with, in a large case as far as even dealing with capital projects that are coming in, like the Plymouth Racetrack and the PLA and all of that stuff is creating opportunities as far as within communities.
Thank you. Delegate Simmons.
Thank you, Madam Chair, and thank the panel. Just interested, we talk about limitations and we look at all these programs when it comes to mitigating some of these excessive sentences to juveniles in your lifetime. When you come to going back out into society, can you tell me what's the role that expungements play, and is that a limitation that it's compounded by what you're trying to get accomplished here?
I can try to speak to that.
So first, I'd like to hear from him and see if it affected him, and if not, we can move it to you. Thank you.
I knew that I wouldn't be able to get my charge expunged, but it did affect me in ways with jobs. But I just kept pushing because I knew no matter what, I wanted to be successful in life. And it becomes an issue no matter how long a person be home at times, right? But I wish it was more opportunity that wouldn't just hold us accountable for those things we done when we were 16, 17 years old.
Right.
But I can't get my charge expunged, so.
Right. So do you, now because of that, do you feel like you're still being punished?
In ways I am, because I'm not who I am when I was 16 years old.
Right.
And I shouldn't be held by what I did when I was 16. I paid my debt to society, and I'm continuing to live my life, in a productive way. And when do I have a chance to not have to look at that on my back or affect me if I choose to move forward to go into business for myself and other opportunities? Those things still continue to come up, but I don't use it as a crutch to hold me back. But I know for some people, it hurts them more because they don't have some of the connections that others may have. So that's why I say it's very important for those of us who come out to be able to connect with each other and direct people to those opportunities. That's going to give us an opportunity to show our true value.
Thank you. If you wanted to add something to it.
Thank you.
I don't think I can say it better than
Okay,
that.
thank you. Appreciate it.
All righty. Members, do we have any other questions? Seeing none, we're going to move on to our panel online. We just have Sarah Citroni. There's no one in the waiting room. So.
Yeah, I think they canceled.
And Daryl Green is not. I'm sorry?
They canceled because of the time.
Okay, and Daryl Green as well, correct? Okay.
They've submitted written.
Okay, thank you very much. That concludes our testimony for House Bill 759, and that concludes our bill hearings for the day. Thank you, committee.